Hi, good morning, everyone. So, we thought that this was my idea that we'll have 2-3 sessions with you. It will be more about some of the important topics for the prelims examination. We are going to be discussing static topics only. So, this is not that we are discussing something which is new or something which is unique as such. For those of you, those who have been my student in the classroom, you may find this repetitive. Okay, so it's your choice whether you are wanting to attend this or not, but it would be a good refresher just in case you want to revise some of these important topics. Then you could attend these 2 sessions. We'll be having one today and tomorrow at 5 o'clock, and then next week also we have planned one session which will be on some of the most important judgments of the courts. But again, through those judgments, the idea is not to cover the judgments as such, but to cover some of the basic concepts of polity with the help of those particular judgments. Now, for this session, we will be having 25 topics today, and we'll try and cover 25 topics today and then 25 topics tomorrow. Let's see if we are able to achieve our target. The second thing is that along with the session, I have requested them. I was working late till night because there was some other work also. I sent them the file at 3 a.m. in the morning. So there is some worksheet also that I have made of the previous year questions and some of the practice questions for you on the basis of the topics that we are going to discuss. So because just knowing is not enough when it comes to prelims or for that matter the UPSC exam. It is important for you to be able to practice and to apply the concepts that you know as well while solving the question. So there will be almost 64 questions if I'm not wrong in that worksheet, and probably some time during the session they should be able to get a printout of it and hand it over to you. In any case, I mean, if you want an e-copy of that, I have asked them to upload it on the link through which they are streaming this session live on YouTube, so you could get access to it from there as well. Please don't come to me after the session asking ki sir ye PPT upload kar do, ye kar do, wo kar do. This is not in my hand. I have already told them. So you please reach out to the Vision IAS team and ask them for uploading that and stuff. I'm not the one who handles the Vision IAS YouTube account and goes and uploads things. Okay. So please don't come to me and waste your time and waste my time, and because that's not going to be of any help. Ab iske andar, the thing that we are going to be doing in this session is that we will cover some of the most important topics of polity, and the question is that how did I decide which are the most important topics? Okay, I am not any Nostradamus who can predict that what are the topics that UPSC is going to ask this year. It's very difficult to say that, but you can predict important topics in my opinion on the basis of previous year questions. So what we did was that we did an analysis of the last 13-year questions of prelims from 2013 to 2025, and on the basis of that we have identified that which are some of the topics which are most repeated in prelims related to polity, and we'll be discussing concepts related to that. And as I said, that you will get the worksheet as well, so it's important that you not only attempt the questions in that worksheet, but you go back and you attempt questions related to the topics that we are going to be discussing in the class today, right? Especially the previous year prelims polity questions. For example, the first topic that we'll be discussing will be related to parliamentary functioning and various aspects related to parliament. So I would expect that once this session is over, you go back and try and solve those questions, because if you're not applying the knowledge or whatever that we have discussed in the class, then all of this is going to be of no use at all, right? Anyway, so these are some of the topics that we'll be discussing. So the first, I've divided this into different cohorts. Today's topics, which are 1 to 25, we have divided it into 3 cohorts. The first one is section A, which is related to Parliament and legislature. So we'll be taking up questions and topics related to Parliament and legislature. So if you look at the weightage of Parliament and legislature, you will find that almost 32% of the questions, 1/3 of the questions that have been asked in polity in prelims since 2013, they are related to Parliament and the functioning of the legislature. So almost 1/3 of the questions are related to Parliament. The good thing is that most of these questions are very simple and easy to solve if you know the basic concepts. Okay, so what are the topics that we'll be taking up? We'll be talking about, so this is the list of the topics that we'll be covering under Parliament and Legislature. So we'll have Money Bill, Finance Bill, Financial Bill, Speaker of Lok Sabha, Deputy Speaker, Parliamentary motions, procedures, etc. Of course, I'll not be discussing everything because then it will become a foundation course and it will not be possible for me to cover all the topics in detail, but I'll discuss some of the most important concepts with respect to these particular topics. Okay, so let's start with the first one, and this is related to the money bills, finance bill, financial bills. So you must have seen that quite a few questions have been asked in the prelims examination related to money bills, financial bill, finance bill, etc. First and foremost, it is important to understand what is the distinction between these three bills: money bills, finance bills, financial bills. What are they a subset of each other, so on and so forth? What is the definition of a money bill? What is the definition of a financial bill? And then also to know what is the special procedure that is supposed to be followed with respect to each of these bills. Now, of course, many of you, because you may be attending my class for the first time, I believe that the only way to study polity is to have a copy of Constitution with you, right? So I hope that you people have a copy of Constitution. Just in case you don't have, my suggestion will be that please download it right away. I'll give you half a minute. अगर आपके पास अभी नहीं है, तो अपने स्मार्टफोन के ऊपर Constitution of India का PDF डाउनलोड कर लीजिएगा. Reason for that is because मैं तो अपना यहाँ से पढ़ा दूंगा. But if you really want to be able to retain the concept, then it's important that you have the Constitution in front of you, because ultimately UPSC will test you on the basis of the basic knowledge with respect to the Constitution of India, right? So that's the thing. Anyway, so let's talk about money bill, and let's talk about the definition of money bill. So as you people would know, the definition of a money bill has been provided for in Article 110 of the Indian Constitution, right? So that's where the definition of a money bill has been provided for in the Indian Constitution. In a general sense, a bill that is related to only money matters is called as a money bill. In a general sense. Specifically, if I should know the definition of the money bill, then for that I'll have to refer Article 110 of the Constitution. So a bill that relates to only money matters, in general I can call that as a money bill, right? But exactly what is the definition of a money bill? For the purposes of this chapter, I am reading Article 110. A bill shall be deemed to be a money bill if it contains only provisions relating with all or any of the following matters. So it should relate to only the matters which are contained in Article 1110 clause 1. This is one important concept that you have to keep in mind. Now, what are the areas related to money matters which are covered under a money bill? The imposition, abolition, remission, alteration or regulation of any tax. So if you are imposing any new tax, removing any tax, remission of a tax, alteration of a tax, regulation of any tax, then such a bill would be called as a money bill. Now this should ring a bell in our mind. If an income tax act is passed by the Parliament, it would contain provisions only related to taxation. So therefore, an income tax act would be nothing but a money bill according to provisions of Article 110 clause 1 subclause A. This is how we have to study. Why? Because in the exam, UPSC is not necessarily going to give you this. What UPSC will do is that they will give you 4 statements, 5 statements or whatever, and they will ask which of the following would be a money bill. Now, an income tax act would be a money bill. So they will give you an income tax act or a bill that relates to imposing income tax. That's what UPSC is going to give you as a statement. So you should exactly know what is the meaning of a money bill according to provisions of Article 110 clause 1, right? One of which is imposition of a tax. Then it says regulation of borrowing of
money or the giving of any guarantee by government of India or the amendment of law with respect to any financial obligations undertaken or to be undertaken by government of India. So if Indian government borrows any money, or if there is any guarantee that is supposed to be given with respect to any money that is borrowed by the government of India, if there is any law that regulates this matter, then such a bill would also be a money bill. A money bill may contain provisions related to Article 1110 Clause 1, Subclause A only. It may contain provisions related to Article 1110 Subclause A and Subclause B also. Then also it will be a money bill. It can contain multiple matters covered under Article 1110 Clause 1. It can contain only one matter that has been contained under Article 1110 Clause 1. But it should contain only those matters which are covered under Article 1110 Clause 1. Then it says, the custody of consolidated fund or the contingency fund of India, the payment of monies into or withdrawal of money from such funds. So if there is any money that is supposed to be withdrawn, that is, there is any money that is supposed to be deposited in consolidated fund, contingency fund, taking the custody of such a fund, under whose control this fund is going to be. Who's going to be exercising control over consolidated fund? If there is a law that is passed with respect to such a matter, then such a bill would be called as a money bill. Now, here is one interesting thing. What students get confused about. Contingency fund is mentioned here. Now, what you must understand is that we all know that contingency fund is a contingent fund. If any money is supposed to be withdrawn out of contingency fund, we do not require parliamentary approval, because the entire purpose of contingency fund would be defeated if you would require parliamentary approval, because ultimately contingency fund is for emergency purposes. If it is for emergency purposes, then in that particular case, if I have to go and take the parliamentary or the legislative approval, would it not take a lot of time? So contingency fund does not require parliamentary approval. But here is the thing. There is consolidated fund of India from which a certain portion is taken out and is kept as contingency fund, for which you do not require any approval. But ultimately you are spending taxpayers' money. You need to take approval of the representative of the people. So that approval for expenditure of money out of contingency fund is taken later by the government from the parliament. It is not taken at that point of time when I need money for some disaster relief or I need money for some contingency situation. So what happens is that, as you people would know, how much money is there under the contingency fund of India as of now? यार एक तो नई मतलब इंफॉर्मेशन रखो यार, 500 करोड़ बासी इंफॉर्मेशन लेके आ रहे हो तुम. हाँ, व्हाट इज द अमाउंट ऑफ मनी दैट इज पार्क्ड अंडर कंटिजेंसी फंड? कौन सी किताब पढ़े हो भाई? 500 करोड़. हाँ बताओ. It's all of you are appearing in prelims exam this year, right? Or you are doing time pass here. कितना रुपया होता है कंटिजेंसी फंड के अंदर पार्क्ड? कितना है मैक्सिमम लिमिट? यस, बताइए. You people are preparing for prelims exam this year, right? Have you read the basics? See, this class is not to make up for your foundation course, guys. This is for those who are serious about prelims examination, considering the fact that prelims is round about 80 days from now. We have less amount of time remaining. We are covering some of the important topics of polity and revising them. बताइए भाई. हाँ भाई, हर्ष बोलो. 30,000 crore rupees. 30,000 crore rupees. We raised the limit under the contingency fund. It was 500 crore rupees earlier. कोविड के बाद इसको 30,000 करोड़ कर दिया गया. कैसे किया गया? मनी बिल के थ्रू. A money bill was required to raise the limit of the contingency fund. तो अभी क्या है कि 30,000 करोड़ रुपीस, 30,000 करोड़ रुपया आपने निकाल के कंसोलिडेटेड फंड से अलग जगह पे रखा हुआ है जिसका नाम है कंटिजेंसी फंड. इफ आई हैव टू विड्रॉ मनी फ्रॉम कंटिजेंसी फंड, प्लीज पीछे से आइएगा, पीछे से आइए. इफ आई हैव टू विड्रॉ मनी फ्रॉम कंटिजेंसी फंड, then in that case I do not require any parliamentary approval at that stage. No parliamentary approval is required. So suppose कीजिए some disaster occurred in the country, I will take, let's say, 50 crore rupees out of the contingency fund as Government of India. For this, I do not require any parliamentary approval, but later on, I will have to refill this contingency fund. Where will that money come from? From the consolidated. ये जो 50 करोड़ रुपया खर्च किया, this will come from consolidated fund of India. तो जब मैं ये withdraw करके contingency fund में डालूंगा, तब तो money bill लगेगा. At that point of time, I will definitely require a law, because no money can be withdrawn out of the consolidated fund of India without the approval of the legislature, because the money does not belong to the government, it belongs to people. And who's going to be giving the permission to the government on behalf of the people of the country? The legislature. Do you understand this? So, what you have to remember is, when Article 1110 Clause 1 Subclause C says custody of consolidated fund or contingency fund of India, or the payment of monies into or withdrawal of money from such funds. This may create a confusion in your mind that when the money is being withdrawn out of the contingency fund, does it require a law? No, it does not. At that point of time, it does not. That's the arrangement that we have created. But at later point of time, when you're going to refill the contingency fund, you will definitely require a, and that would be called as a money bill. Then it says appropriation of money out of consolidated fund. Declaring of any appropriation means withdrawal of any kind of money out of the consolidated fund of India. Declaring of any expenditure to be expenditure charged on the consolidated fund of India, or increasing the amount of any such expenditure. Now see, again, very interesting point. If at any point of time I declare any expenditure to be a charge expenditure on the consolidated fund of India, and if such a bill contains only such a provision declaring a particular expenditure to be a charge expenditure on the CFI, it will be called as a money bill. For example, let's say that you have some institution that you have created. Let's say we have created the Data Protection Authority. ऐसा कुछ करके हमने एक body बनाया. And I said that the salaries of the members of the Data Protection Authority will be a charged expenditure on the consolidated fund of India. Will be a charge expenditure on CFI. अगर ऐसे किसी एक्सपेंडिचर को मैं डिक्लेयर करने के लिए एक चार्ज एक्सपेंडिचर एक बिल लेकर आता हूं, and such a bill contains only and only this provision, then such a bill would be a money bill. But here is the interesting thing that you need to know. When would this bill become a financial bill? Financial bill type 1, as we call it. If this bill not only contains the provision that the salaries and the allowances related to the members of the Data Protection Authority would be a charge expenditure on Consolidated Fund of India, and the bill also includes the appointment method of members of this body. एक random example दे रहा हूं. Or the bill also contains provisions related to the removal procedure or the removal method for the members of this body. Or the bill also contains qualifications required to be a member of this body. Or the bill also contains what are the functions of this body. Then does such a bill contain only and only provisions related to Article 1110 Clause 1? No. Then such a bill ends up becoming a financial bill type 1, because a money bill contains provisions only related to money matters, whereas a financial bill type 1, as we call it, not only contains matters under 1110 Clause 1, but some other matters as well. इसके लिए थोड़ा प्रोसीजर अलग है, इसके लिए थोड़ा प्रोसीजर अलग है, which we'll see very shortly. Then it says the receipt of money on account of Consolidated Fund of India or the public account of India, or the custody or issue of such money or audit of account of union or of a state, or any matter incidental to any of the matters that have been specified in subclauses A to F. If a bill contains only and only these matters, then it will be called as a money bill. Now, what is the special procedure that is supposed to be followed with respect to a money bill? For that, I will have to read the provisions under Article 109 of the Indian Constitution. So the special procedure with respect to a money bill has been mentioned in Article 109. What is that special procedure? Very simply, we all know what it is. A money bill shall not be introduced in Council of States. So it can only be introduced in Lok Sabha, not in Council of States, House of People. After a bill has been passed by the House of People, it shall be transmitted to the Council of States for its recommendations, and the Council of States shall, within a period of 14 days from the date of the receipt of the bill, return the bill to the House of the People with recommendations, and the House of the People may thereupon either accept or reject all or any of the recommendations of the Council of States, which means that only thing that the Council of States can do once a money bill is passed by the House of People and sent to it is that either you accept it or you provide recommendations to change the bill. Whether or not your recommendations will be accepted or not is a decision that is in the hands of the House of the People. And second, and a very important thing to keep in mind, is that if you do not respond to the message from the House of People within 14 days, the bill shall be deemed passed by the Parliament of India and it shall go to the President of India for approval. Is that understood to everyone? So, in this case, the powers of Council of States are limited. Powers of Council of States are limited. ये हम केवल मनी बिल की भी बात कर रहे हैं. Special procedure with respect to a money bill. Why are they limited? Either recommend, or you accept, or if you do not act for 14 days, the bill shall be deemed passed after 14 days. Right? Then, if the House of the People does not accept any of the recommendations of the Council of the State, the money bill shall be deemed to have been passed by both the houses in the form in which it was passed by House of People without any of the amendments recommended by the Council of States. Only thing that Council of States can do is that it can recommend changes to a money bill. It cannot actually make changes. You can suggest changes. Whether or not those changes will be accepted depends upon House of People. Then, if a money bill passed by House of People and transmitted to Council of States for its recommendation is not returned to the House of People within the 14 days period, it shall be deemed to have been passed by both the houses of the Parliament at the expiration of the said period in the form in which it was passed by the House of People. जिस form के अंदर House of People ने bill Council of States को भेजा था, अगर 14 दिन में Council of States उस पर reply नहीं करता है, the bill shall be deemed passed. ये हम सबको पता है. Now, here is the interesting thing. अब आती है बात आर्टिकल 1110 पे, वापस आइए. A bill shall not be deemed to be a money bill. Now this is a very important provision because UPSC can set a question on this. A bill shall not be deemed to be a money bill by the reason only that it provides for imposition of fines or other pecuniary penalties, or for the demand of payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, regulation of any tax by any local authority or by the body for such purposes. So let us say if there is any penalty that is imposed, or if there is any fee that is charged by the government for some services that it is providing, such a bill would not be a money bill. ये bill money bill नहीं होगा. If there is a bill that is allowing tax to be imposed by a local authority, उसको भी money bill नहीं बुलाया जाएगा. Provisions of the Constitution हैं, exceptions हैं, याद रखना जरूरी है इसको. Then, if any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. So when the bill is transmitted from the House of People to the Council of State, it must carry a certificate from the Speaker of the Lok Sabha that this is a money bill. And the powers of the House of People are curtailed with respect to this particular bill. There shall be endorsed on every money bill when it is transmitted to the Council of States under Article 109 and when it is presented to the President for assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. Right? Now, if you look at the provisions of Article 117, we will get some more information about some procedure that is supposed to be followed with respect to a money bill and a financial bill. यार पीछे से एंट्री अलाउ कीजिए सर, यहां से एकदम सामने से मेरे लेके आओगे तो कैसे होगा ना क्लास में. A bill or an amendment making any provision for any of the matters specified in clauses A to F of clause 1 of article 110 shall not be introduced or moved except on the recommendation of the president, and a bill making such provision shall not be introduced in council of states. Now this is the important thing. Article 117 clause 1 ये कह रहा है that if the bill is related to, if a bill is related to article 1110 clause 1 के related provisions, such a bill would not be introduced in House of People, and second, it requires prior recommendation of President of India. President of India means the Council of Ministers, Government of India. Now you have to understand one thing. This provision will apply on this bill and it will apply on this bill, both. Yes or no? A bill may contain provisions only related to Article 110 clause 1. A bill may contain provisions related to Article 1110 clause 1 and something else. When it is something else, it is this bill. When it contains only provisions related to Article 110 clause 1, then it is a money bill. But in both cases, such a bill requires initial recommendation of the president for introduction in the parliament. Without that, the bill cannot be introduced in the parliament. Is that understood to everyone? Right? So this is the difference between a financial bill and a money bill. Now here is the interesting thing. If you read the provisions of Article 117 clause 3, it says that a bill which if enacted and brought into operation would involve expenditure from consolidated fund of India shall not be passed by either house of parliament unless the president has recommended to that house the consideration of the bill. अब ये दो bills हैं, एक Article 110 clause related one only, 1110 clause 1 plus some other matter. I gave you the example. Let us say that there is a bill which is passed by the Parliament of India to create new stadiums in the country. And it also includes what the specification or the size of each of these stadiums. These are the worksheets for those of you, those who have come in late. These are the worksheets that contain some of the questions related to the topics that we are going to be discussing in today's session. Okay. मिल जाएगा भाई, मिल जाएगा. हाँ, थोड़ा सा मंदिर का प्रसाद नहीं है तो थोड़ा सा पेशेंस रखो तुम, एक ही आदमी है ना, ठीक है. तो you will get it, and for those who are attending the session online, this will be uploaded online as well on the YouTube streaming link, right? So that even if you are not able to come here physically, you are able to do some practice related to the concepts that we are discussing here in the class. अब देखिए आर्टिकल 117 क्लॉज 3, मैंने एक बिल पास किया पार्लियामेंट के अंदर जिसमें आई एम गोइंग टू बी क्रिएटिंग स्टेडियम्स, आई एम गोइंग टू बी स्पेसिफाइंग व्हाट द साइज ऑफ द स्टेडियम्स इज गोइंग टू बी, हु इज गोइंग टू बी मैनेजिंग दी स्टेडियम्स एक्सेट्रा. बट creation of these stadiums is going to involve some kind of expenditure on the consolidated fund of India. In that case, such a bill would need to follow the provisions under 117 clause 3. Such a bill is what we call as a financial bill type 2. Financial bill type 2. Financial bill type 2 is a bill that involves expenditure from consolidated fund of India if enacted. ऐसा कोई बिल जो कि consolidated fund of India के ऊपर कोई financial implication create करता है, उसको financial bill type 2 कह रहे हैं. अब इस बिल के केस में केवल एक ही कंडीशन फॉलो करनी जरूरी है जो कि आर्टिकल 117 क्लॉज 3 में दी हुई है. Now what is that? A bill, if enacted and brought into operation, would involve expenditure from so and so, shall not be passed by either house of the parliament unless the president has recommended to the house for the consideration of the bill. So, there is no limitation on this bill being introduced in Council of States. This bill can be introduced in Council of States as well as House of People. There is no problem on that. This bill also, powers of Council of State are same as House of People. Same goes for this bill as well. इस वाले में भी सेम है, क्योंकि यहां पे केवल एक ही कंडीशन फॉलो करनी है. ये बिल लोकसभा में ही इंट्रोड्यूस होगा और इनिशियल रिकमेंडेशन ऑफ प्रेसिडेंट से इंट्रोड्यूस होगा. बट वंस दैट इज डन, हियर ऑल्सो पावर्स ऑफ हाउस ऑफ पीपल आर सेम एज पावर्स ऑफ काउंसिल ऑफ स्टेट्स. मतलब दिस इज जस्ट लाइक एनी ऑर्डिनरी बिल वंस इट इज इंट्रोड्यूस्ड इन द पार्लियामेंट. This one, to be very honest, is as good as any ordinary bill. I'll tell you the reason why it is required for the president's recommendation to be given before the bill is passed by either house of the parliament. भाई आप कुछ पैसा खर्च कर रहे हैं. सपोज कीजिए प्राइवेट मेंबर ने एक बिल इंट्रोड्यूस कर दिया और वो पार्लियामेंट में बिल पास हो जाता है. उस बिल से भारत सरकार के ऊपर 1000 करोड़ रुपए का कॉस्ट इंप्लीकेशन आ जाता है. Should some permission not have been taken from the government of India before such a bill be passed by the parliament? That's why president's recommendation is required before the bill is passed by the parliament, not for introduction in the house. In case of money bill and financial bill type 1, you require initial recommendation of the president for introduction of that bill in the parliament. But here you only require the permission, the assent, the recommendation, whatever you may want to call it, of the president before the bill is passed by the parliament. मतलब introduce हो गया, discuss हो गया, third reading से पहले, third reading समझते हैं, final vote से पहले, you need the recommendation of the president in both the houses of the parliament for passing that bill. So the only condition that is supposed to be fulfilled in case of a financial bill type 2 is that you require recommendation of president before passing the bill in either house. Either house मतलब दोनों ही हाउसेस के अंदर आपको इनिशियल रिकमेंडेशन ऑफ द प्रेसिडेंट चाहिए होगा बिफोर द बिल इज पास्ड, चाहे वो लोकसभा हो या राज्यसभा हो. दैट्स इट, दैट्स ऑल. नाउ the concept is clear to us. अब वो UPSC कोई भी क्वेश्चन पूछे we can answer. But let me also tell you, UPSC asked a question a few years back where they had given some statements about finance bill. Usually 90% of the times, 99 in fact I would say, a finance bill is a bill for appropriating money out of the consolidated fund of India. Sorry, it's a bill which is for the imposing income tax, right? दो bills होते हैं बजट के अंदर, appropriation bill, finance bill. Appropriation bill is to take money out of consolidated fund, and the finance bill is to impose taxes. So, bill that is related to or that contains tax provisions in our parliamentary democracy, such a bill is called as a finance bill. 99% of the times a finance bill only and only contains tax provisions, nothing else, and therefore it should not surprise us that 99% of the times a finance bill is nothing but a money bill. अब यूपीएससी ने पता नहीं क्या खिचड़ी पकाई एक बार. दे आस्क्ड फिनेंस बिल और आंसर उन्होंने ऐसा दिया जैसे कि फिनेंस बिल नहीं फाइनेंशियल बिल लिखा उन्होंने. The correct answer which was provided by UPSC was as if that they have mentioned financial bill, but they actually had mentioned finance bill. Some people give an explanation that no, UPSC was correct. Why? Because a finance bill can also be a financial bill type 1. Because a finance bill may not contain only tax provisions, but it may contain some other matters as well, and therefore the answer given by UPSC was correct. You want to buy into that argument, you can buy that, but my problem is UPSC never ever, आप कभी भी पेपर उठा के देख लीजिएगा, एक्सेप्शंस के ऊपर क्वेश्चन नहीं बनाता है, वो जनरल रूल पे क्वेश्चन बनाता है. जनरल रूल क्या है? फाइनेंस बिल मनी बिल होता है. अब मैं एग्जाम में बैठ के सोचूं नहीं फाइनेंस बिल फाइनेंशियल बिल भी हो सकता है, फाइनेंशियल बिल टाइप 1, मेरे को नहीं लगता, राइट? सो द आंसर विच यूपीएससी मेस्ड अप इन दैट क्वेश्चन इन माय ओपिनियन, बट एनीवे, forget about it. That's not in your control. What is in your control is to know this concept. I hope that this is clear to all of you now, right? So this is a very important concept as far as the prelims is concerned. If you see, this is one of the most tested topics in the UPSC prelims examination. Okay, तो अगर आप देखेंगे, almost 9 questions have been asked on this particular topic in from 2013 to 2025. ये एक टेबल सा मैंने बनाया हुआ है, बट वी डोंट नीड टू नेसेसरली इसको रटना नहीं है, समझिएगा. आर्टिकल 1110 क्लॉज 1 ओनली मनी बिल, आर्टिकल 1110 क्लॉज 1 प्लस समथिंग एल्स फाइनेंशियल बिल टाइप 1. इफ इट इन्वॉल्व्स एक्सपेंडिचर आउट ऑफ कंसोलिडेटेड फंड ऑफ इंडिया इफ ब्रॉट इनटू फोर्स, फाइनेंशियल बिल टाइप 2. In case of money bill, powers of the Rajya Sabha are curtailed, and such a bill can be introduced only in the House of People, and it requires the certificate of the Speaker of Lok Sabha, and it also requires initial recommendation of the President, because provisions of Article 117 Clause 1 will kick in. In case of Financial Bill Type 1, only 2 conditions. It can be introduced only in House of People, and initial recommendation of the President is required. After that, procedure is the same as any ordinary bill. That also makes me ask one more question. Can there be a joint sitting possible in case of a financial bill? Yes. Why? Because it's just like an ordinary bill, Baba. In case of a money bill, no joint sitting, because there can be no disagreement. Council of States has no powers anyway. Is this clear to everyone? Right? Okay. So, ये सब चीजें हमने discuss कर ली हैं. What is a money bill and all of those things. As you people would know, the most famous controversy related to a money bill, whether it's a money bill or not, and all of that, was with respect to the Aadhaar bill, right? The government of India introduced the Aadhaar bill in the parliament and got it passed in the parliament as a money bill. A petition was filed in the Supreme Court. Now this is the interesting thing. Article 1110 clause 3 says that the decision of the speaker shall be final on whether a bill is a money bill or not. But हम तो यहाँ पे कह रहे हैं कि अगर स्पीकर के डिसीजन को कोर्ट में चैलेंज भी किया गया तो वो जुडिशियल रिव्यू कोर्ट ने अलाउ किया. उसमें बड़ी इंटरेस्टिंग बात ये भी है दैट जस्टिस डी.वाई. चंद्रचूड़, द फॉर्मर सीजेआई, व्हेन ही वाज नॉट द सीजेआई, he was also on the bench, and he disagreed, he dissented in the judgment, where he said that this is not a money bill, this is a fraud which has been committed on the Constitution of India by declaring it as a money bill. See, because ultimately, why is the government trying to introduce a bill as a money bill? To circumvent the Rajya Sabha, especially when they do not have enough support for the bill in the Rajya Sabha. That is what happened in case of Aadhaar bill. So the question is, can it be judicially reviewed? The answer is yes. Does Constitution as such allow it? No. But has the court said that judicial review of whether a bill is a money bill or not can happen? Yes, but of course in a limited manner, in limited circumstances. Anyway, now let's come to next concept. This one is not necessarily related to Constitution per se, but related to parliamentary functioning. Very simple concept. We'll rush through this. इसमें एक दो चीजें पता होनी चाहिए दैट जो पार्लियामेंट्री डे है उसमें व्हाट इज द फर्स्ट आवर, देन व्हाट इज द सेकंड आवर, then after that there is a lunch, and then after that there is the legislative agenda of the house that is taken up. In this we should know that something like 0 hour is born out of invention. When the parliament would gather at 11, they would conduct their business at 12 of question hour. After that 12 से 1 का समय खाली होता था. 1 to 2 used to be lunch, 12 to 1 is free. What used to happen is two things. One, questions from the question hour would spill over to 12 o'clock. तो पार्लियामेंट में बार बार मांग उठने लगी कि सर क्वेश्चन आवर में हम जितने क्वेश्चंस हैं वो वी आर नॉट एबल टू टेक अप फॉर कंसिडरेशन, सो व्हाई यू डू नॉट अलाउ दीज क्वेश्चंस टू बी extended further into the next hour as well. Second, some people said that, sir, we have a lot of important topics to discuss in Parliament, which we are not able to discuss because, one, Parliament does not meet for a very long time. There are disruptions as well. And then there is not much on the schedule time left on the agenda of the Parliament as well to discuss these topics. So, can we bring up an issue in the morning, tell you by 10 o'clock that we want a discussion on this urgent topic, and if the chair allows, we can have a discussion on that particular topic in the house. The chair allowed it, and slowly it became a convention in India's parliamentary system. Is there any mention of 0 hour in the constitution? No. Is there any mention of 0 hour in the rules and the procedures of the parliament? That also no. Is there any mention of question hour in the constitution? No. Constitution is a broad framework. It does not tell the details of how the parliament exactly is going to function. That is supposed to be determined by the parliamentary rules and procedures that the parliament itself would make. Because it's a sovereign body in many ways. It may not be sovereign like the Parliament of Britain, but our parliament also has some elements of sovereignty. And one of that is that it can decide its own work, how it wants to conduct itself, so they make their rules, etc. Now, few things to remember in question hour. The biggest confusion is with respect to short notice questions. Rest, I am sure all of you know. Short notice questions are also oral questions, which means if it's an oral question, there can always be a supplementary question associated with an oral question. So in a short notice question, you can also ask supplementary questions from the concerned member of the parliament. One more question that I have for you. In question hour, are questions put up only to the ministers or they can be asked from private members of the parliament as well? Yes? Are questions only put up to the ministers or can they be asked from private members also? What is the purpose of question hour? Primarily to hold the government accountable. So, the logical answer that we get is that question hour, questions can be asked only of the ministers, which is the usual practice. But questions can be asked in the question hour from a private member also. This is another important thing that you have to keep in mind. ये बात समझ में आई? एक और इसमें इंपॉर्टेंट चीज है. अब क्यों पूछा जाएगा प्राइवेट मेंबर से क्वेश्चन इन द क्वेश्चन आवर? मे बी द प्राइवेट मेंबर इज चेयरपर्सन ऑफ सम कमिटी ऑफ द पार्लियामेंट एंड आई वांट टू पुट अप सम क्वेश्चन दैट यू टेल मी अबाउट द स्टेटस ऑफ व्हाट द कमिटी इज डूइंग or what is this finding that the committee has put up in its report. I want more clarity on that. I can ask a question. Can a minister ask a question during the question hour? Can a minister ask a question during the question hour? बताओ. यही सब क्वेश्चंस हैं जिस पे यूपीएससी कंफ्यूज करती है और तुम कंफ्यूज होते हो एग्जाम में. बताओ, बोलो भाई. No. Why not? He's not a member of parliament. What? Sorry, Baba. I just said that in question hour, question can be asked from anyone. Minister can also ask a question. What's the problem? भाई कोई लिमिटेशन थोड़ी ना है. देखिए यही सब चीजों में यूपीएससी फंसाती है आपको. क्यों? आप कॉन्फिडेंट नहीं है अपने कॉन्सेप्ट के बारे में. आप एग्जाम में जाएंगे, उसने जरा सा बस कुछ चिंगारी छोड़ी, तुम वहीं पे ही जो है भस्म हो जाओगे. दैट्स द फैक्ट. बिकॉज यू पीपल आर नॉट कॉन्फिडेंट ऑफ व्हाट यू हैव रेड. अरे यू हैव कॉन्फिडेंस इन द फैक्ट ना कि यार व्हाई शुड अ मिनिस्टर नॉट बी एबल टू आस्क क्वेश्चंस? इज ही नॉट अ मेंबर ऑफ द पार्लियामेंट? मेंबर नहीं है क्या वो नहीं पूछ सकता? अभी मैं एक और इसको देखो. अब मैं कैसे अगर मैं यूपीएससी एग्जामिनर होता तो मैं तो बहुत मजे लेता ऐसे ही क्वेश्चन पूछ के. प्राइम मिनिस्टर कैन नॉट आस्क अ क्वेश्चन ड्यूरिंग द क्वेश्चन आवर. 90% लोग इसको सही टिक करके आते हैं. वो बोलते हैं यार प्राइम मिनिस्टर क्यों क्वेश्चन पूछेगा, क्यों नहीं पूछ सकता. देखिए पूछता नहीं है वो अलग बात है, बिकॉज वाई वुड द प्राइम मिनिस्टर आस्क द क्वेश्चन, दैट इज अनदर पॉइंट. बट वाई कैन ही नॉट आस्क अ क्वेश्चन ड्यूरिंग द क्वेश्चन आवर. प्राइम मिनिस्टर कोई आसमान से थोड़ी ना उतर के आए. ही इज ऑल्सो मेंबर ऑफ द पार्लियामेंट, राइट. इफ अ मेंबर ऑफ द पार्लियामेंट कैन आस्क अ क्वेश्चन to any other member of the parliament during the question hour, why can the prime minister not ask question of the other member of the parliament, whether it be a minister or not? Doesn't matter. Do you understand what I'm trying to say here? You need to have confidence in what you have read, and that will only come with clarity. That clarity, that confidence will only come with revisions, with multiple revisions, with practice of questions, where UPSC may do whatever they want to by trying to confuse you. You would be coming out clean on that particular question. That's what UPSC does. यही तो करता है वो. ऑर्डिनेंस पे उसने क्वेश्चन पूछा, ऑर्डिनेंस कैन वायलेट द फंडामेंटल राइट. लोग बोल रहे हैं हाँ जी कर सकता है. क्यों कर सकता है? इज ऑर्डिनेंस नॉट अ लॉ अकॉर्डिंग टू प्रोविजंस ऑफ आर्टिकल 13 क्लॉज 2? एक्सप्लिसिटली लिखा है 13 क्लॉज 3 सब क्लॉज ए के अंदर दैट लॉ इंक्लूड्स ऑर्डिनेंस. सो हाउ कैन ऑर्डिनेंस वायलेट फंडामेंटल राइट्स? आदमी बोल रहा है नहीं करता है. अब आप अगर इतनी बेसिक मिस्टेक करके आएंगे एग्जाम में, क्योंकि एग्जामिनर आपको जानबूझ के कंफ्यूज करने की कोशिश कर रहा है, एंड यू आर गेटिंग कंफ्यूज्ड, दैट इज योर प्रॉब्लम. पेपर इज नॉट डिफिकल्ट, बिलीव मी. देयर इज वन मोर थिंग. Common sense. I have discussed about this earlier as well. Common sense is very, very crucial. 30-40 questions I have always said you will be able to solve with the help of your basic static knowledge. Any good, serious candidate will be able to solve 30 to 40 questions in the paper, but that will not qualify the cutoff. For qualifying, I need to be able to attempt at least 20-30 questions more, with at least an accuracy rate of maybe 80% or 70%. How will I get there? I'll have to use common sense. You may have seen some questions UPSC has asked, where they will, एक उन्होंने question दिया अभी 2 साल पहले, which of the following statements are correct? उसमें एक उन्होंने दिया टी बोर्ड कहां पर है इसका हेडक्वार्टर. एक और कुछ स्टेटमेंट दिया. उसमें यू हैव टू ट्राई एंड फाइंड द एंकर स्टेटमेंट विच यू आर एब्सोल्युटली श्योर ऑफ कि ये तो ठीक नहीं है, एंड देन ट्राई टू वर्क आउट द आंसर अकॉर्डिंगली. टी बोर्ड बैंगलोर में क्या करेगा? व्हाट विल टी बोर्ड डू इन बैंगलोर? दैट इज द फर्स्ट रेड फ्लैग. द मोमेंट यू आइडेंटिफाई दैट दिस स्टेटमेंट इज रॉन्ग, then you can find the right answer to that question. I was looking at one more question. Now they have got into this habit. They gave 3 bodies and they gave in the next column which ministry they fall under. Have you seen that question? देखा है क्वेश्चन ये? नेशनल ऑटोमोटिव बोर्ड पूछा उसने, ठीक है, और उसने सामने लिख दिया मिनिस्ट्री ऑफ कॉमर्स एंड इंडस्ट्री. उसी के नीचे उसने लिखा कॉयर बोर्ड. कॉयर समझते हैं? कॉयर बोर्ड, और उसके सामने लिख दिया हैवी इंडस्ट्री. अब आप पहले खुद सोच के देखो, कैन कॉयर बोर्ड बी मैनेज बाय हैवी इंडस्ट्रीज, मिनिस्ट्री ऑफ हैवी इंडस्ट्रीज? हो सकता है ऐसा? कॉयर क्या हैवी इंडस्ट्री है क्या? नहीं. तो एक तो वही स्टेटमेंट वैसे ही लॉजिक से ही रॉन्ग हो गई वो स्टेटमेंट कि हो ही नहीं सकता ये. तो देन यू थिंक ऑटोमोटिव बोर्ड अंडर मिनिस्ट्री ऑफ कॉमर्स एंड इंडस्ट्रीज हो सकता है, बट देन उसी के नीचे उसने हैवी इंडस्ट्री भी लिखा हुआ है. उसने हिंट भी दिया हुआ है एग्जामिनर ने तुम्हें. यार ऑटोमोटिव इंडस्ट्री कैन नॉट बी coming under Ministry of Commerce and Automotive Board cannot be coming under Ministry of Commerce and Industry. The moment you apply this logic, you will be able to arrive at the right answer. Now, this is not tukkabazi. This is using your common sense. This is using what you generally know about coir industry hoti kya hai. That it is a light industry. How can it be under heavy industry? You use your अब ये कहां से मिलता है knowledge? NCERT पढ़ा है तो मुझे पता होगा. This is my general knowledge that I have to use in the exam to arrive at the right answer. Do not expect that everything will be just straightforward. जैसा पढ़ाया वैसा ही क्वेश्चन आ गया. तो फिर एक बार जो बात बताओ, डिफरेंशिएटर क्या रह गया पेपर में? How will UPSC differentiate between two candidates? They are making questions difficult by giving you unknown information, unknown facts. But they expect that a smart, intelligent candidate will apply that knowledge, common sense, general understanding that they have to arrive at the right answer. And the good candidates do that. Why are they able to do so? Because they practiced a lot. Because उनको अपने concept और अपनी पढ़ाई और अपनी तैयारी में विश्वास है. आप यहां पे क्वेश्चन आवर में ही हिल जा रहे हैं, तो फिर एग्जाम में क्या होगा सोचिए आप. सो वो अपने ऊपर विश्वास होना बहुत जरूरी है. वो विश्वास ऐसे नहीं आएगा बैठ के रोज. इट विल नॉट कम बाय जस्ट चैंटिंग यस आई हैव सेल्फ बिलीफ. इट विल नॉट कम बाय दैट. इट विल कम बाय extensive practice. More and more questions that you solve, you will be able to arrive at that. Anyway, so I hope that this is clear to all of you. Now, a few other things to keep in mind related to this parliamentary procedures, etc. only. No confidence motion. Now, no confidence motion, is it mentioned in the constitution? No. But where does no confidence motion come from? Actually, if you look at it, the genesis of no confidence motion is nothing but which article of the constitution? 75 clause 3. The council of ministers shall be collectively responsible to the house of people. This is the very fundamental of parliamentary democracy. अब यूपीएससी इस पे भी क्वेश्चन पूछ चुकी है. What is the most important idea in parliamentary democracy? The most important idea is this. Try to understand this. People elect representatives and give their powers to them. अपनी पावर जो है लोग representatives को दे रहे हैं. These representatives in turn will choose a government and will give powers to them. If I am giving power to someone, would they not be responsible to me? So government is responsible to representatives of people. Representatives of people are responsible to people. This is the very basis of parliamentary democracy. यही होता है parliamentary democracy. लोगों ने अपने representatives को पावर दी, लोगों के representatives ने सरकार बनाई. लोगों ने सरकार नहीं बनाई डायरेक्ट. And then responsibility flows downwards. So which means that now, who are representatives of people? We can say that Council of State members are also representatives of people, but actually if you look at it, they are not directly elected representatives of people. हमारा सिस्टम ब्रिटेन के सिस्टम पे बेस्ड है. ब्रिटेन के सिस्टम में हाउस ऑफ कॉमन्स ही सब कुछ है. हाउस ऑफ लॉर्ड्स तो एक नॉमिनेटेड चेंबर है, non-elected chamber hai. When it's a non-elected, nominated chamber, then it is not truly representative of the people. In India, the corresponding chamber for House of Commons is House of People, Lok Sabha. So it is House of People. No doubt that Council of States are also our representatives, but they are not our truly elected representatives. Therefore, government will continue to be in power as long as the House of People wants them to continue in power. And this is what is reflected in Article 75 Clause 3. That they are collectively responsible to the House of People, which means that whenever the House of People says, I do not want these people in power, they can remove them. But what is the procedure? That procedure has to be detailed by the Parliament itself, cannot be mentioned in the Constitution. And that is what is mentioned in Rule 198 of the Rules and Procedures of the Parliament. But do we need to remember this rule? No. Rules of Lok Sabha हमें नहीं पता जरूरी है. But just a passing reference would be enough. Which means that a no confidence motion is to basically express lack of confidence in the government. That then brings me to the question. Can a no confidence motion be passed by Rajya Sabha? No. It can only be passed by Lok Sabha. Only Lok Sabha can remove the government. Rajya Sabha एड़ी चोटी का जोर लगा ले कुछ नहीं कर सकती. बिकॉज सरकार बनती भी लोकसभा की वजह से ही है. राज्यसभा में आपकी कितनी भी मेजोरिटी हो क्या फर्क पड़ता है. तो सरकार गिरेगी भी लोकसभा की वजह से. बिल्कुल सिंपल कॉन्सेप्ट है. पर इसी कॉन्सेप्ट को बार बार यूपीएससी पूछती है और बार बार लोग वही गलती करके आते हैं. वेरी बेसिस ऑफ पार्लियामेंट्री डेमोक्रेसी इज दैट, उसने पूछा भी हुआ है एक बार क्वेश्चन, विच ऑफ द फॉलोइंग बेस्ट रिफ्लेक्ट्स द आइडिया ऑफ पार्लियामेंट्री डेमोक्रेसी? दैट द गवर्नमेंट is responsible to the parliament. It derives its powers from the parliament. Does not derive its powers from the people. It derives its powers from the parliament. Parliamentary democracy उसको इसलिए भी कहते हैं क्योंकि the true powers lie with the parliament. Also because ultimately why it is called parliamentary democracy, because government state के दो organs तो एक ही साथ intermingled हैं. Parliament and executive are intermingled into each other. That's why also it's called as parliamentary democracy. Understood? अमेरिका में क्या है? गवर्नमेंट सेपरेट है, पार्लियामेंट सेपरेट है साहब. यहां पे क्या है? द गवर्नमेंट इज विद इन द पार्लियामेंट. सो पार्लियामेंट्री डेमोक्रेसी. अंडरस्टूड टू एवरीवन, राइट? एनीवे, सो दिस इज वन थिंग. देन अपार्ट फ्रॉम दैट व्हाट एल्स? अडजर्नमेंट मोशन. ओके, ये कुछ कुछ डिटेल्स वगैरह हैं, मतलब मैं सब कुछ नहीं डिस्कस कर रहा हूं. ओके, एक चीज और है, नो कॉन्फिडेंस मोशन पास करने के लिए देखिए सिंपल मेजॉरिटी चाहिए. कोई स्पेशल मेजॉरिटी की जरूरत नहीं है. व्हाई? बिकॉज टू रिमेन इन पावर ऑल्सो यू रिक्वायर सिंपल मेजॉरिटी ना. विच इज व्हाट इज सिंपल मेजॉरिटी यार? देयर इज नो टर्म लाइक सिंपल मेजॉरिटी मेंशन्ड इन द कॉन्स्टिट्यूशन. इट इज मेजॉरिटी ऑफ मोर देन 50% ऑफ मेंबर्स प्रेजेंट एंड वोटिंग. दैट्स ऑल. जितने लोग उस समय प्रेजेंट हैं उनके 50% का ज्यादा का सपोर्ट है आपके पास. जी हाँ, तो यू कैन कंटिन्यू इन पावर, you can form the government, or you can be removed from the power if you do not have the support of more than 50% of the people, those who are present and voting in the parliament, in the Lok Sabha at that point of time. Adjournment motion. Adjournment motion is nothing but if there is a matter of urgent public importance that is supposed to be discussed in the parliament, you can bring in an adjournment motion. An adjournment motion is followed by a vote also that happens in the parliament, and it acts like a censure on the government as well. Whether or not an adjournment motion will be accepted depends upon the presiding officer. Is it mentioned in the constitution? Of course not. Again, right? So that's something which we need to keep in mind. Now, another important tool in parliamentary democracy is cut motions. When the budgetary proposals are introduced in the parliament, if I want to make some changes to those budgetary proposals, what we call as demand of grants, how can I do so? There are cut motions that can be moved by the members of Lok Sabha with respect to those demand of grants. Those cut motions can be only introduced by members of Lok Sabha. Again, why? Because, understand, it involves expenditure, and any matter that comes under only expenditure matters will be nothing but a money bill. And who has the powers to decide whether a money bill will be passed or not? Lok Sabha. Rajya Sabha has no role. So another important point to remember is demand of grants are discussed in the Rajya Sabha. They are discussed, but they are not voted upon. Demand of grants are voted upon in the Lok Sabha. Three kind of motions, cut motions, can be introduced by a member of Lok Sabha on a demand of grant. One, what is called as the policy cut. I do not agree with the entire policy of the government to spend money on this item, item X by Z, whatever it is. This expenditure ABC that you have said should not be made at all. It's called as a policy cut. Complete disapproval of the policy. Demand of grant maybe 10,000 crore under a scheme. I do not want that scheme to be approved. I will move a policy cut motion. If when the motion is voted upon and it is passed, it becomes a resolution. Yes. तो अब पॉलिसी कट मोशन जो है वो क्या करता है, डिमांड ऑफ ग्रांट को 10,000 करोड़ रुपए से 1 रुपया कर देगा. गवर्नमेंट विल गेट ओनली 1 रुपी. नाउ यू विल से बाय 1 रुपी, जीरो क्यों नहीं कर दिया? Because budgeting head has already been created, line item has already been created in the budget. You can't remove it now. It will create a mess. So what you can do is you can reduce the amount to rupee 1. If I want a specific amount to be reduced in that particular demand of grant, I can suggest what is called as an economy cut, where the demand of grant will be reduced by some X amount. Government has asked for 50,000 crore rupees for MG Narega. I believe that this work can be done in 30,000 crore rupees. I will introduce a cut motion, which will be an economy cut motion for reducing the demand of grant by 20,000 crore rupees. Right? Third one is token cut. We all know what it is. It's just token. I want to just express my disapproval. I want to just express my disapproval of a particular policy of the government. I'm not saying that you reduce it to rupee 1 or make the scheme defunct. I'm not saying that you reduce the amount by some X or Y amount. I'm just saying that you please register my grievance. That's all. Token cut motion reduces the demand of grant by 100 rupees. 5,000 crore रुपए में 100 रुपया कम भी हो गया तो क्या हो जाएगा? Nothing will happen. But it's just a token cut. Understood? Now here is the interesting thing. Let's say if UPSC asks, as per the constitution, if the policy cut motion is passed by the Lok Sabha, the government must resign. What do you think the answer will be? Is it correct or wrong? This is wrong. Where is it mentioned in constitution? See, you must understand one thing. Policy cut means that Lok Sabha has disapproved a policy of the government. पॉलिसी कट अगर अप्रूव हो गया तो इसका मतलब क्या है? किसके पास मेजॉरिटी है? सरकार के पास तो नहीं है, क्योंकि सरकार अप्रूव करवा लेती है उसको, डिमांड ऑफ ग्रांट को. इफ द गवर्नमेंट हैज नॉट बीन एबल टू गेट अ डिमांड ऑफ ग्रांट अप्रूव्ड, दैट मींस दैट हु हैज मेजॉरिटी इन द पार्लियामेंट? हु हैज मेजॉरिटी इन लोकसभा? Probably opposition, or at least the government does not have. So what will happen? The opposition can go to the government and say that, boss, you lost the vote for this policy cut motion. That means you do not have enough numbers, please resign. The government doesn't resign, that's their choice. Let's say the opposition is very confident that the government is indeed a minority government now. What can they do? They can go to the president. They can say that, sir, this government is a minority government. What will the president do? President will call up the prime minister. He will say that I am hearing these news. What do you think? What can be done? So he'll say, sir, okay, let's go for a confidence vote. We will introduce a confidence motion in the house. और दूसरा तरीका क्या हो सकता है? Opposition can say, no, government is in minority, we will introduce a no confidence motion against the government. ऐसा भी हो सकता है कि पॉलिसी कट मोशन पास हो गया, सरकार खुद से ही बोले भाई हमारे नंबर्स नहीं है, वी डोंट वांट टू टेक दिस फर्दर, विल रिजाइन. बट देयर इज नो कंपल्शन ऑन द गवर्नमेंट टू रिजाइन. इट्स जस्ट, one can say, a matter of convention that the government should resign. Whether or not they resign is their prerogative. No confidence motion passed, government must resign. Is this also mentioned in constitution? No. But the fact is that it is derived from article 75 clause 3. The council of ministers is collectively responsible to the house of people. If the house of people does not have confidence in you, they have passed a no confidence motion, then you must resign. If they still do not agree to do so, the president must go ahead and he must tell the prime minister that you please resign now. It has never happened till now. It has never happened till now. Matters will go to court or something, if at all, something like, if it comes to this situation. But अभी आज तक कभी नहीं हुआ कि कोई सरकार जो है नो कॉन्फिडेंस वोट हार के भी बोल रही हो कि नहीं हम सरकार में कंटिन्यू करेंगे. नहीं होता. आप एकदम, you can't be committing daylight robbery, right? There are political implications as well. Is this clear to everyone? Right? So adjournment motion, policy cut motions, token cut motion, economy cut motions, etc., and the the no confidence motion. Then few other things. Parliamentary control over executive, how it is maintained, and so on and so forth. Another important concept on which UPSC asks questions, private member bill. There are two types of members in the parliament. A person who is a minister and a person who is not a minister. A private member can belong to either the ruling party or the ruling coalition or the opposition parties. Doesn't matter. If you're not a minister, you're a private member. That's all. Understood? So now if a private member wants a bill to be passed in the parliament, can they introduce the bill? Yes. There are rules and procedures of the parliament with respect to that. Usually, the legislative agenda with respect to private member bills is taken upon on Friday. Friday is the day that is allocated for private member bills. Do you require initial recommendation of the president for introduction of a private member bill? No. Now, but here is my question. Can a private member bill introduce a money bill? कहाँ लिखा है कि he cannot? Why? The very purpose of the procedure under Article 117 Clause 1 is that if a private member goes on to introduce a bill that has money implications, you must take first the permission of the Government of India. That's all. So, who says that a private member cannot introduce a money bill? देखिए यही मैं बार बार बोल रहा हूं, ऐसे ही हां या ना मत बोल दीजिएगा बिना दिमाग लगाए. सोचिए, आपने अभी मनी बिल के रिस्पेक्ट में प्रोविजंस पढ़े? कहीं पे भी प्राइवेट मेंबर, मिनिस्टर ये सब लिखा था क्या? दूसरी बात, आपको लगता है कि ये प्राइवेट मेंबर और मिनिस्टर वाला मैटर जो है कॉन्स्टिट्यूशन में लिखा होगा? और तीसरी बात, सबसे इंपॉर्टेंट बात, the reason why you require initial recommendation of the president for introduction of a money bill in the parliament is precisely this, that if a private member comes and introduces a bill that has some cost implications, financial implications, they should not be able to do it so without the approval of the union government or state government, whatever the case may be. President means union government. President अपने से नहीं दे रहा recommendation. He is giving it on the advice of Council of Ministers. Is that understood to everyone? Right? So anyway, again, so it does not require prior presidential recommendation is the point that you have to understand. Can a private member introduce a constitutional amendment bill? Can a private member introduce a constitutional amendment bill? बताओ. Why not? There is no limitation, na? Is there anything mentioned in Article 368 that only the government can introduce a constitutional amendment bill? But tell me something. What are the chances of a private member constitutional amendment bill getting passed? Literally next to zero. But can a private member introduce a constitutional amendment bill? Why not? Again, it does. अब ये चीजें ना किताब में नहीं लिखी होंगी. देखिए, ये आपको खुद ही सोचना है कि क्यों नहीं कर सकता प्राइवेट मेंबर बिल प्राइवेट मेंबर कॉन्स्टिट्यूशनल अमेंडमेंट बिल इंट्रोड्यूस. 368 में तो कुछ नहीं लिखा है ऐसा. देयर इज नथिंग मेंशन्ड. ऑल दैट इज रिक्वायर्ड इज दैट अ कॉन्स्टिट्यूशनल अमेंडमेंट बिल कैन बी इंट्रोड्यूस्ड इन ईदर हाउस ऑफ द पार्लियामेंट अंडर आर्टिकल 368. इट मस्ट बी पास्ड बाय अ majority of not less than 2/3 of the members present and voting and a total majority of the house concerned, and it shall be given assent to by the president. That's all. और कुछ नहीं लिखा है. तो कौन कह रहा है कि इसके लिए आपको सरकार की परमिशन चाहिए या प्राइवेट मेंबर नहीं इंट्रोड्यूस कर सकता? यही सब चीजों के अंदर वो आपको कंफ्यूज करने की कोशिश करता है बार बार हर साल. एंड पीपल गेट ट्रैप्ड इनटू दैट बिकॉज अगेन आई एम सेइंग, बिकॉज जो आपने पढ़ा है आपको उसी पे कॉन्फिडेंस नहीं है. And I always say, therefore, to my students, those of you who have studied from me, please read it from the bare act. You've read it from 368, you know कि यार ऐसा तो कुछ लिखा ही नहीं है 368 में, तो फिर क्या है? Then why should I get confused in the exam? Understood? Yes, someone had a question. बोलो. क्या कहना चाहते हो? तुम अब डू यू हियर योरसेल्फ व्हाट यू आर सेइंग, या तुम कंफ्यूज्ड ही पैदा हुए थे? मेरे भाई, मैंने बस इतना लिखा है, इट डज नॉट रिक्वायर एनी काइंड प्राइवेट मेंबर बिल इन जनरल। तू एक्सेप्शन पे चला गया, तूने मनी बिल ढूंढ लिया उसमें। प्राइवेट मेंबर बिल इन जनरल डज नॉट रिक्वायर द प्रेसिडेंशियल रिकमेंडेशन, ठीक है ना? अगर प्राइवेट मेंबर बिल मनी बिल होगा तो फिर तो मनी बिल का प्रोसीजर लगेगा ना, नहीं? अरे भाई, ये जेनेरिक स्टेटमेंट है, जेनेरिक स्टेटमेंट। मनी बिल क्या है? स्पेसिफिक एग्जाम्पल है या जनरल एग्जाम्पल है? स्पेसिफिक है ना, तो फिर ठीक है, ठीक है यार। देखो, कॉन्सेप्ट को ना खिचड़ी मत पकाओ अपने दिमाग में, सिंपल है जिंदगी बहुत। कॉन्स्टिट्यूशन इज वेरी सिंपल, डोंट कॉम्प्लिकेट इट इन योर माइंड। क्योंकि ये लिखा है तो इसका तो मतलब ये होना चाहिए सर मनी बिल के लिए भी ऐसा हो सकता है क्या? अरे मनी बिल तो स्पेसिफिक एग्जाम्पल है ना मेरे भाई, मनी बिल तो स्पेसिफिक एग्जाम्पल है। अगर क्रिकेट, पता है क्रिकेट, अगर बॉल बैट्समैन के पैड पे लगे ऑफ स्टंप के बाहर, लाइन इंपैक्ट क्या बोलते हैं, पॉइंट ऑफ इंपैक्ट आउटसाइड दी ऑफ स्टंप होता है, तो आउट होता है क्या? आउट होता है कि नहीं होता है? एलबीडब्ल्यू दे सकता है अंपायर, आउट दे सकता है। कभी देखा डीआरएस? 3 चीजें देखता है वो, क्या देखता है बताओ? वेयर इज बॉल पिचिंग, फिर व्हाट इज द पॉइंट ऑफ इंपैक्ट, और तीसरी, अबे अल्ट्रा एज नहीं देखता। एंड द थर्ड थिंग ही चेक्स इज वेदर द बॉल इज गोइंग टू हिट द स्टंप्स और नॉट, ठीक है? इफ द बॉल hits the batsman on his pad and the point of impact is outside of, it is generally not out. But in what condition is it out? When the batsman does not play a shot. The rule is, if the batsman does not offer a shot and the ball hits him on his pads, even if the point of impact is outside, the umpire can give it out. अब ये तो एक्सेप्शन है ना, ये एक्सेप्शन है, ये जनरल रूल नहीं है, ठीक है? दिस इज नॉट अ जनरल रूल, दिस इज एन एक्सेप्शन, सेम थिंग हियर। एनीवे, सो प्राइवेट मेंबर बिल, कॉलिंग अटेंशन मोशन, आई एम नॉट गेटिंग इनटू दैट। अनदर थिंग, कॉन्स्टिट्यूशन ऑफ इंडिया, डज इट टेल हाउ मेनी सेशंस ऑफ द पार्लियामेंट शुड बी देयर? Only thing that it says is that Parliament should meet not for more than a gap of 6 months. That's all. 2 sessions of the Parliament should not be conducted more than 6 months apart. That's all. Which means that ऐसा भी नहीं कह रहा कॉन्स्टिट्यूशन की साल में 2 सेशन होने ही चाहिए पार्लियामेंट के, ऐसा भी नहीं कह रहा है कैलेंडर ईयर में 2 सेशन ही हो, जरूरी नहीं है, जरूरी नहीं है। बट अल्टीमेटली इट विल हैपन दैट you will end up having minimum of 2 sessions of the parliament in a year. How many sessions of parliament do we have? Normally 3. Who decides the duration of the session of the parliament? Who decides the duration of the, is the duration of the session of the parliament mentioned in the constitution? No. Where is it mentioned? Rules and procedure. Arey, there is no parliamentary convention yaar. How is the duration of the session of the parliament decided? Please tell me. Who decides it? हाँ? बोलो बोलो। स्पीकर? इतना बड़ा हो गया स्पीकर कि वो अब मतलब पार्लियामेंट के सेशन की ड्यूरेशन डिसाइड करेगा? सेक्रेटरी ऑफ पार्लियामेंट। भाई उसने बोला स्पीकर और तूने तो मतलब और नीचे ले गया, तू सेक्रेटरी पे। सेक्रेटरी पता कौन होता है? आईएएस अफसर होता है। देश की पार्लियामेंट कितने दिन चलेगी ये आईएएस अफसर डिसाइड करेगा। सेक्रेटेरिएट में कौन होते हैं? मतलब देश के नेता लोग नहीं, जो आप इतने एग्जाम क्वालिफाई करके आए हैं वो डिसाइड करेंगे कि पार्लियामेंट कितने दिन फंक्शन करेगी। ऐसा हो सकता है? तुक्का मत मारो यार, तुक्का मत मारो, सिंपल है। गवर्नमेंट डिसाइड्स। हाउ? Why does government decide? On what basis does government decide the duration of the session of the parliament? Please tell me. बताओ। For what? And yes. बाबा मतलब तुम तो यार बिल्कुल एकदम मेरे को कंफ्यूज कर रहे हो कि मेरे को ये सेशन लेना चाहिए था कि नहीं। अब ये 85 देखा है आपने? 85 ऑफ द कॉन्स्टिट्यूशन पढ़ा है कभी? 85 पढ़ा है। The president shall from time to time summon each house of the parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. तो मतलब who decides when the parliament session will begin? Please don't say president. Ultimately, who's deciding this? You say president aided by council of ministers, I will accept that answer. You say president, then it's a problem. It's a decision taken by council of ministers. Who decides prorogation of the session? What is prorogation? When the session is going to end, who decides it? Again president, on the aid and the advice of. So then who decides the duration of the session of the parliament? Council of ministers, right? तुक्का मत मारो यार जबरदस्ती। सेक्रेटेरिएट पे पहुंच गए, लोकसभा स्पीकर बोल रहा है, कोई बोल रहा है, कन्वेंशन से हो रहा है। सरकार डिसाइड करती है भाई। When is the parliament session going to start? When it is going to end? सरकार डिसाइड करती है। प्रोरोगेशन ऑर्डर प्रेसिडेंट इशू करता है, डिसोल्यूशन ऑर्डर प्रेसिडेंट इशू करता है। डज द प्रेसिडेंट ऑफ इंडिया इशू द डिसोल्यूशन ऑर्डर इन हिज डिस्क्रेशनरी कैपेसिटी फॉर लोकसभा? हाँ? No, yes. What is the answer? It may depend. If the minority government, a council of ministers that has lost confidence of the Lok Sabha, comes to the president and tells them to dissolve the Lok Sabha, president can refuse the advice. Why? Because, see, again understand one thing. Concept देखिए वही है। House of Representatives chose government. So government enjoys powers as long as the House of Representatives wants them to. Now, because House of People has chosen the government on behalf of House of People can go and tell the president that you please dissolve House of People. But when can this happen? Only when the House of People has enough confidence in the government. If the government has lost the confidence of House of People, who the hell are they to speak on behalf of the House of People to go and tell the president that dissolve the House of People? Do you understand? So if it is a minority government, what does that mean? A government that does not enjoy the confidence of the Lok Sabha goes and tells the president, sir, please dissolve the Lok Sabha. President will think and see whether he should do that or not in his discretionary capacity. Why? Because president will see. ऐसा तो नहीं है कि there is a possibility of formation of an alternate government. Why should I prematurely dissolve the House of People? Listening to a government that itself does not enjoy the confidence of the House of People. I'll give you an example. If tomorrow Rahul Gandhi goes to the President of India and says that, sir, please dissolve the House of People, will the President do so? Why not? He will say, कौन है भाई तू? Why are you coming? He will say, sir, मेरे पार्टी के 50 लोग हैं। वो तो 50 है ना। You do not have majority of the House support. You get letters from 300 people. You come to me. You prove that the government is in minority. I'll dissolve it. But who are you? Same thing. Simply because I am Prime Minister does not mean that I necessarily enjoy the confidence of the Lok Sabha. President will see whether I have the confidence of the Lok Sabha or not. If not, I go to the President, dissolve the Lok Sabha, he will not listen to me. It depends. Normally, it is supposed to be done on the aid and the advice of Council of Ministers. But not all the circumstances. Is this clear to everyone? Right. Again, very simple basic concepts, guys. Very simple concepts. But need to be understood. Who issues the order for adjournment sine die? Presiding officer. Adjournment sine die means an order issued without any specific date and time when the House will reassemble. Now my question is, and this is the question that UPSC is also asked. Can the President issue a prorogation order without adjournment sine die order issued by the presiding officer? See, normally what happens is, you have to understand again. Normally, let's say, आज क्या date है? 6th of March है? Let's say Parliament session is going on, 6th of March 2026. At 5 p.m. today, the Speaker of Lok Sabha, will issue adjournment order, where he will say that we will meet on this fixed time and date. Now, let's say the Speaker knows that the last day of the session of the Parliament, as was decided earlier, was 18th of March. Let's say 18th March is last day of this session of the Parliament. So what will Speaker do? Speaker at, let's say, 5 p.m. or 6 p.m. or whatever the time is when he wants to end the proceedings of the House that day, Speaker or the presiding officer will issue an adjournment sine die order. Because आज last day है. अब next कब Parliament मिलेगी मुझे नहीं पता. ये तो government decide करेगी. तो he will say adjournment sine die without any date and time. And then same day or next day or within a few days or within a few weeks, the President of India will issue the order for prorogation of the session of the Parliament. But let's say earlier it was decided that the session will continue till 8th March, but war happens. Right? डोलांड भाई का कोई वैसे भी पता नहीं है. कौन किस दिन कहां पे उसका बम गिराने का मन हो, दुनिया को वो वॉर में ले जाए, God knows. He has already put the entire world into war now. It is right at our doorstep. I hope you understand that. अब ये मत सोचने लगना कि वॉर हो जाए, एग्जाम पोस्टपोन हो जाए. आधे लोग यही उम्मीद कर रहे होंगे कि एक आधा बम भाई आसपास भी गिरा दे हमारे. इंडियन ओशन तक तो पहुंच ही गया है, तो ज्यादा दूर नहीं है. ठीक है. Anyway, the point I am trying to explain here is, let's say 18th of March was decided as the last day of the session of the Parliament, ongoing session, budget session. But suddenly war happens, something happens, government decides नहीं, हमें 12th of March को ही session end करना है. Session चल रहा है. और इतने के अंदर स्पीकर को बताया जाता है, पार्लियामेंट्री अफेयर्स मिनिस्टर टेल्स दैट यू नीड टू एंड द सेशन राइट नाउ, और यू नीड टू एंड द सिटिंग टुडे. सो द स्पीकर में probably issue an adjournment order that today's proceedings are over, we will meet on 13th of March. But 13th of March morning or 12th of March night, the President of India will issue the order for prorogation of the Parliament and the session will be over. There is no need for adjournment sine die order to be issued by the President of India per se. So there is no need, कोई requirement नहीं है. Prorogation order can be issued by the President of India at any point of time. It does not require an adjournment order to be issued by the presiding officer per se. Is that clear to everyone? And definitely does not require an adjournment sine die order. Okay. Anyway. Right, so there is no minimum number of days that have been mandated, etc. President summons the session. Gap between two sessions should not be more than 6 months, etc. Now, Speaker of Lok Sabha पे आते हैं. Again, important topic. Few things to keep in mind. What is the tenure of the Speaker of Lok Sabha? Don't know. Is there a fixed tenure of Speaker of Lok Sabha? No. That is one, right? Speaker of Lok Sabha is elected by the Lok Sabha. He can resign by submitting his resignation to the Deputy Speaker. But now I have a question. Do we have a Deputy Speaker of the Parliament of Lok Sabha at this point of time? So then who will the Speaker of Lok Sabha go and submit the resignation to? Who will he submit? Who will the Speaker of Lok Sabha submit his resignation to if he wants to resign? बताइए. जी. God knows. I don't know. Constitution says that he has to submit it to the Deputy Speaker. There is no Deputy Speaker. Actually, the problem is that government has created a mess by not having a Deputy Speaker. Constitution says that the date and the time of the election of the Deputy Speaker is supposed to be decided by the Speaker of the House. But Speaker of the House has not assigned any time only in last so many years. So there is no Deputy Speaker of the Lok Sabha. Normally there has been a convention in India that the post of the Deputy Speaker will go to the, yes, it will go to the opposition. And there is no fixed rule that it will go to the single largest party or whatever. It goes to the opposition. It goes to a consensus candidate of the opposition. ये convention है, पर कोई deputy speaker ही नहीं है. So we don't know whom he will go and submit the resignation to. Now anyway, now coming back to this. So there is no fixed tenure of the Speaker of the Lok Sabha is what you have to keep in mind. How is the Speaker of Lok Sabha chosen? Through a vote made in the Lok Sabha. Members of the Lok Sabha from among themselves choose one person to be a Speaker of the Lok Sabha. Question is, what is the kind of majority that is required for the election of the Speaker of the Lok Sabha? Simple majority. Normally convention is, government says that this person will be a nominee for the Speaker of the Lok Sabha and the entire house votes on that. But this is a convention. As you may have seen in the recent times, when it was proposed that Mr. Om Birla should be the Speaker of the newly elected Lok Sabha, the opposition objected. They said that we do not want this person to be the Speaker of Lok Sabha. Put up some other candidate. Government said no. Government अड़ गई. तो opposition ने बोला ठीक है, फिर हम भी अपना candidate खड़ा करेंगे. So let the vote happen in the house. Government said that the opposition is breaking the convention of doing what? Of electing a consensus candidate. देखिए speaker है, तो आप चाहते हैं कि वो सबकी सर्वसम्मति से elect हो. पर अब अगर दोनों में सहमति नहीं बन रही है तो वोट हुआ. वोट के अंदर majority of the votes of course were go in favor of the government's nominee and he was chosen as the Speaker of the Lok Sabha. Another important thing. Speaker of Lok Sabha continues to hold the office till the just right before the first sitting of the newly elected Lok Sabha. So the newly elected Lok Sabha, right before its first sitting, till that time the Speaker of the Lok Sabha continues to remain in his office to maintain continuity of Lok Sabha as an institution. That's all. But there is a problem. If he is going to resign right before the first sitting of the newly elected Lok Sabha, then who is going to, one, preside over the proceedings of the Lok Sabha when the Lok Sabha elects its new Speaker? Someone has to sit in the chair, right, to conduct the proceedings of the House. That is one. Secondly, someone has to administer oath to the members of the Lok Sabha as well. Now, here is the interesting thing. Constitution says that the President will decide who shall be the person responsible for administering oath to the members of the newly elected Lok Sabha. So you can see that provision there. This is mentioned in Article 99. Every member of either House of Parliament shall, before taking his seat, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in third schedule. या तो President oath दिलवाएगा और some person appointed by the president is going to be responsible for subscribing the oath to a newly elected member of the parliament. Now, Rajya Sabha, this is not a problem because you have the chairman, deputy chairman, etc. always there. The problem is with respect to Lok Sabha because you do not have the speaker of the Lok Sabha because he will resign just before the first sitting and sitting होने से पहले सबको ओथ दिलवाना जरूरी है. So what the procedure that is followed in India is very simple. What we do is that the President of India appoints a member, a MP of House of People as what is called as pro tem speaker or temporary speaker. This is someone from among the house. How is this person chosen? It's something which is mentioned in rules and procedures and conventions of parliament. What is the procedure? Procedure is basically what happens is that Secretariat of Lok Sabha will prepare a list of 10 names. ये सब rules and procedures में लिखा है, ठीक है? They will prepare a list of 10 names of Lok Sabha. They will be the senior most members of the Lok Sabha on the basis of the number of years that they have spent in the Lok Sabha. These 10 name list will be sent to PMO. PMO out of this will select 3 names. And these 3 names will then be forwarded to the President of India. In this 3 name, there will be one person who will be pro tem speaker. The other 2 people, their job will be to aid the pro tem speaker in what? In administering oath. Pro tem speaker, one, तो इसके 2 काम हैं. One, to administer oath along with these 2 other people. Can these 2 people also administer oath? Yes, why not? Because president has chosen them according to provisions of article 99 that we just read. And then the second thing is to preside over election of new speaker. Once the new speaker is chosen, pro tem speaker will go back as a regular member of the parliament, as a regular member of the Lok Sabha. Can the pro tem speaker vote when the election of the speaker is taking place? He cannot vote in first instance. He is in the chair. He is in the chair. So he has a casting vote. If there is a tie, he can vote. Otherwise, he does not vote. Otherwise, see, you have to understand, chair himself is deciding whom he should be voting for in the first instance. Doesn't happen. बात कास्टिंग वोट तक आती नहीं है. ऐसा आज तक तो कभी नहीं हुआ कि स्पीकर ऑफ लोकसभा में इतना प्रॉब्लम हो गया हो कि एक वोट पे बात. अगर स्पीकर ऑफ लोकसभा पे ही बात फंस जा रही है तो आप सोचिएगा कि मतलब सरकार की क्या नंबर है फिर लोकसभा के अंदर. किसी भी दिन सरकार गिर सकती है. So doesn't happen, has not happened till now. Understood? Anyway, so this is another thing. Now, how is the removal done? Removal of the speaker is, what is the ground for the removal of the speaker of Lok Sabha? What are the grounds for the removal of the speaker of Lok Sabha? There are no grounds mentioned in the constitution for the removal of the speaker of the Lok Sabha. House has to decide. If a majority of the members, then members of the house, vote in favor of removal of the speaker will be removed. Then members, जिसको हम क्या कहते हैं? Effective majority. Effective majority is nothing but, so effective majority or effective membership is nothing but total membership minus vacancies, जिसको हम constitution में कहते हैं then membership of the house. If a majority of then membership of the house decides to vote against the speaker of the Lok Sabha, then the speaker shall be removed. Does the Rajya Sabha have any role to play in removal of speaker of Lok Sabha? Does the Lok Sabha have any role to play in removal of the vice president or the chairman of Rajya Sabha? Yes. In Rajya Sabha, the resolution has to be passed by a majority of then membership of the house. In Lok Sabha, it has to be just approved, which means that simple majority would be enough of members present and voting. Then there is one more question that I have. What are the grounds in the constitution for the removal of the vice president of India? Violation of constitution. Where is the provision related to removal of the vice president of India mentioned in the Indian constitution? Article 67 clause B. Please check 67 clause B. Is there any ground mentioned there for the removal of the vice president of India? No. Vice president of India to be removed, there is no ground specifically. Then if I flip the question, for the removal of the chairman of Rajya Sabha, what is the ground? Is there any ground? Is there any ground mentioned for the removal of the chairman of Rajya Sabha? Another question. Is there a procedure provided for the removal of the chairman of Rajya Sabha in the constitution? There is no separate procedure provided for the removal of the chair. Please remember, chairman of Rajya Sabha is an ex officio position. You get that office by the virtue of being elected the vice president of India. बात समझ रहे हैं? जब आप वाइस प्रेसिडेंट इलेक्ट हो जाते हैं तो आप ऑटोमेटिकली चेयरपर्सन बन जाते हैं. तो चेयरपर्सन पहले इलेक्ट होता है या वाइस प्रेसिडेंट पहले इलेक्ट होता है आदमी? तो रिमूव कौन सा होगा पहले? सो रिमूवल ऑफ अ पर्सन एज अ चेयरमैन, देयर इज नो प्रोसीजर. देयर इज ओनली प्रोसीजर फॉर रिमूवल ऑफ. Another question. What is the majority that is required in the Rajya Sabha for the removal of the deputy chairman of Rajya Sabha? What is the kind of majority that is required for the removal of deputy chairman of Rajya Sabha? Arey, don't look at my faces, guys. Same. Majority of the then membership of the House, effective majority. Yaar, have you seen Article 90 of the Constitution? A member holding office as deputy chairman of the Council of State shall vacate his office if he ceases to be a member of the council. May at any time by writing under his hand address to the chairman resign his office and may be removed from his office by a resolution of the council passed by a majority of all the then members of the council. Same ही तो है. Deputy speaker, speaker, deputy chairman, all three of them are supposed to be removed as per a resolution passed by a majority of the then membership of the respective house. So question is, does Lok Sabha play any role in the removal of the deputy chairman of the Rajya Sabha? No. Does Lok Sabha play any role in removal of deputy chairman of Rajya Sabha? No. Is that clear to everyone? Right? So another important thing. इसमें एक जो चीज ध्यान रखनी है, स्पीकर के रिमूवल में, डेप्यूटी स्पीकर के रिमूवल में, डेप्यूटी चेयरमैन के रिमूवल में, तीनों केसेस में, और इनफैक्ट वाइस प्रेसिडेंट के रिमूवल में भी एटलीस्ट 14 days नोटिस हैज टू बी गिवन so that the person can prepare his defense. Whoever you are removing, the person can prepare his defense. One is that. Secondly, this decision should not be taken in haste. It's a constitutional position. See, their expenditure and salaries are the charge expenditure on the consolidated fund of India. It's a very important constitutional office. भाई पूरी पार्लियामेंट को चलाने का जिम्मा इनके शोल्डर्स के ऊपर है. They have the responsibility of running the Parliament of India. So there should be some time gap that should be given when the motion is moved and finally when it is taken up for voting in the House. Is that understood to everyone? Right? Again, some very small basic things that you have to keep in mind. Who gets the position of the deputy chairman of the Rajya Sabha? Is it a person from the opposition, government? Is there anything on this? It can be anyone. He can be a nominee of the opposition. He can be a nominee of the government. It depends. Who has majority in the Rajya Sabha? Is that understood to everyone? Right? So small things that you need to remember. That is there any ground mentioned for the removal of the Vice President of India? The answer is no. Is there any ground mentioned for removal of President of India? What is that? अरे, violation of Constitution. Proven misbehavior कहाँ से आ गया? Proven misbehavior and incapacity are the grounds for the removal of the judges of the Supreme Court and the High Court. Not for the President of India. It is violation of Constitution. Is the term violation of Constitution defined anywhere in the Constitution of India? No, it is not. How can a term like violation of constitution be defined anyway? Don't you think that it will be too difficult to define a term like violation of constitution? There has been no court judgment as well on this particular matter because this matter has never come to the court. There has never been an attempt made to remove any president of India. Anyway, so see, you just need to understand one thing, guys, that just reading a book or just attending a class is not going to be enough. You have to make the effort to revise things on your own as well. Only then you will be truly able to grasp the concepts and would be able to do well in the exam. Okay. Another question. Is the Speaker of the Lok Sabha chairperson of any of the committees of the Lok Sabha? Which all committees? You should know this. Committees में ज़्यादा नहीं पता होना चाहिए, but committees में हमें दो तीन चीजें जरूर पता होनी चाहिए. So, which all committees is the Speaker of the Lok Sabha chairperson? Yes, Parliamentary Affairs Committee, or there are two more. Rules Committee, and then third, एक तो बिजनेस एडवाइजरी कमेटी होता है जो पार्लियामेंट्री अफेयर्स कमेटी, बिजनेस एडवाइजरी कमेटी जो भी है, ठीक है, रूल्स कमेटी एंड जनरल पर्पस कमेटी. These are the three committees of which the Speaker of the Lok Sabha is a chairperson of. Another question. Committees of the Parliament, are their members elected or nominated? What is the procedure for the, or are they chosen by someone? What is the procedure for the method of choosing the members of committees of the Parliament? It's a mixed method. It depends upon which committee we are talking of. For example, my question is, how are the members, do you know about department related standing committees? When were they established? When were DRSCs established in India? Does anyone know? 1993. Okay. Factual information but important. अगर आपने कभी भी DRSCs पढ़ा होगा, सबसे पहली चीज ये लिखी होती है that department related standing committees were established in 1993. How many department related standing committees are there as of now? 24. How many members are there in each of the department related standing committees? 31. How many from Lok Sabha? How many from Rajya Sabha? 21 and 10. Right? How are the members chosen? Do you know? How are the members of department related standing committees chosen? What is the tenure of a person who's chosen to a department related standing committee? 1 year. How are they chosen? The presiding officer chooses them. How? On the basis of the strength of a particular party in the house. So if a party has, let's say, 50% of the seats in Lok Sabha, they will get 50% of the seats in the department related standing committees. What will happen is, the representative of that party, whoever has been chosen by that party, will go and communicate to the speaker that this is the people whom we want to be on these specific committees, department related standing committees of the Parliament. Do you know about Public Accounts Committee? Committee on Public Undertakings? Estimates Committee? These are the three most important financial committees of the Parliament. How are their members chosen? See, they have a very important role to play. They hold the government accountable in financial domain. So therefore, their members are chosen through election by a method of single transferable vote and proportional representation. Okay. Public Accounts Committee. The rule says that a minister cannot be a member. Estimates Committee, same. Why? Because these committees are supposed to hold the government accountable. If a minister himself goes on to become a member of these committees, then the functioning of these committees would be compromised. Understood to everyone? Small thing. See, now committees as a topic usually is asked more in mains analytical topic. What is the utility of committees? What is the purpose that is served by them? All those kind of questions. What are the challenges with respect to their functioning? What are their achievements? But you must also understand that UPSC can ask a question in prelims exam as well, but they will not go into specifics of every committee, but some committees you should know. Public Accounts Committee, what is the strength? That it has 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. Earlier it used to have only members from Lok Sabha. Estimates Committee is a very unique committee because it has all the members only from Lok Sabha. So some of these little bit of details you should remember in your mind. They are important for prelims exam. Not everything. अब ये नहीं जरूरी पता करने का कि ethics committee का क्या composition होता है. नहीं जरूरी है. Doesn't matter. Unless it has been a lot in news, you don't need to bother about it. Right? So you need to be aware of these small things. Another question is, let's say if the deputy speaker, while he is presiding over the proceedings of the Lok Sabha, gives a ruling, he interprets the constitution or interprets one of the rules of the Lok Sabha. Can you appeal against the decision of the deputy speaker to the speaker of the Lok Sabha? No. You must understand one thing. उस समय जो चेयर में बैठा है वही भगवान है. In a way. Whoever is sitting in the chair at that point of time as the presiding officer, whether it is deputy speaker, whether it is speaker, or whether for that matter it is someone else who has been chosen when both of them are not present, their ruling and order and interpretation is final. What they say is final, done and dusted. You can't go and say to the speaker कि sir ये आपके deputy speaker ने ऐसा decision दिया. You can't do anything about that. That's another important point which you need to keep in mind. Okay. So again, certain things that you need to keep in mind as far as the position of speaker, deputy speaker, etc. is concerned. Then another important thing, when the speaker of the Lok Sabha, his resolution for removal is under consideration, who presides over the proceedings of the Lok Sabha? When the speaker of the Lok Sabha's removal is under consideration in Lok Sabha, who will preside over the proceedings of the Lok Sabha? Deputy Speaker. Can the speaker speak, participate and vote while his removal is under consideration in the Lok Sabha? Yes. Who has the casting vote in such a situation? Deputy Speaker. Whoever is there in the chair. Don't say no one. How can it be no one? No one can have a casting vote. अरे जो मैंने अभी क्या बोला, जो चेयर में बैठा है वही वहां पे भगवान है. Speaker का removal is under consideration. He is just going to act like any ordinary member of the parliament. Deputy Speaker consideration for removal is happening, then he will act like ordinary member of the parliament. Understood to everyone? Another thing which you have to keep in mind, chairman of Rajya Sabha. Is he a member of Rajya Sabha? No. Can he, in normal circumstances, participate in the proceedings of the Rajya Sabha? Can chairman of Rajya Sabha participate in the proceedings of Rajya Sabha? अरे यार, how can he participate in proceedings of Rajya Sabha ना? He is not a member of Rajya Sabha. मैंने क्या बोला? Simple statement है. Can the chairman of Rajya Sabha in normal circumstances participate in proceedings of Rajya Sabha? No. When can he participate in proceedings of Rajya Sabha? When his removal is under consideration in the House. Can he vote when his removal is under consideration in the House? No. He cannot. He is not a member. But principles of natural justice say that at least give the poor guy a chance to defend himself when his removal is under consideration. That's all. He can represent himself. He can speak for himself. Why are you removing me? What you are putting the allegation, that is wrong. But he cannot be participating in the proceedings of the Rajya Sabha in general, nor can he vote in the proceedings of the Rajya Sabha. But then he has a very exceptional power, which is that of a casting vote. Because he's sitting there in the chair, and if there is a tie that happens between the opposition and the ruling party or whatever on any particular matter, to break that tie, he can cast what is called as a tiebreaker vote or a casting vote. Is that clear to everyone? Yes. Again, nothing that you don't know. I'm sure that many of you or most of you would have already read these concepts, but the problem is that we did not revise them properly or we did not pay them enough attention. That's why it's important that when we are doing the second reading, third reading of whatever that we have read, we pay more attention to the smaller things. Then the larger things we will remember anyway. Our mind functions in such a beautiful manner. अगर मैं छोटी चीज याद रखूंगा तो बड़ी चीज तो अपने आप मेटा कॉन्सेप्ट तो वैसे ही याद रह जाएगा मुझे. And this kind of revision you need to do for the other subjects as well. Please remember, please do not run after कि मैं ये वाला करंट अफेयर्स पढ़ लूं और वो पढ़ लूं, इससे क्वेश्चन आ जाएगा, उससे आ जाएगा. Ultimately in prelims exam, static is what is going to get you through. Please remember, if everyone else is getting the question right in polity and you are getting it wrong, then you are in a mess because you will have to compensate for that question somewhere. और 30 क्वेश्चन तो देता है यूपीएससी, कितना भी मुश्किल पेपर हो. 2023 पेपर वाज वेरी डिफिकल्ट, बट तब भी 30 क्वेश्चन तो ऐसे थे जो हो सकते हैं स्टैटिक से ही सिर्फ, और स्टैटिक ही बचाएगा उसमें आपको मुश्किल पेपर में, क्योंकि करंट अफेयर्स का भरोसा नहीं है. और स्टैटिक में भी पॉलिटी, ज्योग्राफी, इकोनॉमी एंड टू सर्टेन एक्सटेंट मॉडर्न हिस्ट्री. इसके अलावा और किसी टॉपिक या किसी भी सब्जेक्ट का भरोसा नहीं है. दिस इज नॉट टू डिमीन दोज अदर सब्जेक्ट, बट द प्रॉब्लम इज कि वो क्वेश्चन ही ऐसे सेट करता है. आप कितना भी एंशिएंट मिडिवल आर्ट कल्चर पढ़ जाइएगा, वो देखेगा कैसे कैसे क्वेश्चन डालेगा एग्जाम के अंदर. History optional students find it difficult to solve those questions. I am not saying that you do not study ancient medieval art and culture and make that stupid mistake. Don't do that. But revise these topics, polity, geography, economy, and modern history as many times as possible. Because this is what is the true core of the prelims examination. Anyway, parliamentary committees, we have already discussed some of these things. So I am not getting into this. ओके ये सब हमें कुछ अच्छा, इसमें कुछ ना एक कुछ इन्फॉर्मेशन गड़बड़ हो गया तो वो देख लेना. जैसे यहाँ पे पब्लिक अकाउंट्स कमेटी का 29 मेंबर्स लिख दिया है, सो दैट्स नॉट द कॉम्पोजिशन, एंड दिस ऑल्सो वी हैव डिस्कस्ड. नाउ अ फ्यू थिंग्स विद रिस्पेक्ट टू कंसोलिडेटेड फंड, कंटिंजेंसी फंड दैट वी नीड टू नो, राइट? द फंड्स अंडर द पार्लियामेंट, देयर आर प्रोविजंस इन द कॉन्स्टिट्यूशन दैट वी शुड हैव अ लुक एट. 266, 267. Please have a look at them once quickly. Please have a look at 266 once, part 12. So, consolidated fund and public accounts of India and of states, subject to provisions of 267 and to provisions of this chapter with respect to assignment of the whole or part of net proceeds of certain taxes and duties to the states, all the revenues received by Government of India or loans raised by the Government of India by the issue of treasury bills, loans or ways by means and by loans or ways and means, advances, and all monies received by the government in repayment of all loans shall form one consolidated fund to be entitled the Consolidated Fund of India. So see, what you have to remember is, UPSC may again give you statement, which of the following part a form of the Consolidated Fund of India? If there is some borrowing that is made by Government of India, where will it go? Consolidated Fund. If there is any kind of tax money that is raised by the Government of India, where will it go? If there is some kind of loan that is given by international organization to the Government of India, where will that go? कंसोलिडेटेड फंड ऑफ इंडिया, सब कुछ कंसोलिडेटेड फंड ऑफ इंडिया में जा रहा है, एक्सेप्ट वन थिंग, मनी which is supposed to be given back to the people, which the people have given to the government as an investment or with some kind of an assurance that will be given back to them, does not form a part of consolidated fund of India. Rather, it goes into what is called as public account of India. Understood? Do you require any kind of approval of the parliament for removal of money from public account of India? No. But see, you have to understand one thing. You do not require approval at that time, but at some point of time you will have to replenish the public account of India. Where will that money come from? Consolidated fund. For that you will require a money bill. Similar kind of situation is with contingency fund also. Public account, सरकार पैसा खर्च करती रहती है, but they have to keep replenishing it. Contingency fund, they have to specifically go back to the parliament and tell that this is the amount of money that we spent on contingency from contingency fund. You please give us approval now to replenish this money from the consolidated fund of India. So that's why they often say that public account of India is almost as if it's the money which the government owns as the, or as if the government is banker. वो bankers money है एक तरीके से, because बैंक के अंदर पैसा बैंक का थोड़ी ना है. It belongs to people. Same way, public account of India, money does not belong to the government. It belongs to the people of the country. Anyway, so now all the other monies, public monies received by or on behalf of government of India or government of state shall be credited to public account of India. All the other monies means money which is not loan, money which is not borrowing, money which is not coming from treasury bills, money which is not coming from revenue, non-revenue sources. The money for which the government needs to pay back to the people will be going into public account of India. Then, no money out of consolidated fund of India or consolidated fund of a state shall be appropriated except in accordance with law and for the purposes provided in the manner in the constitution. Contingency fund we have already discussed. This is nothing but, this is the money that is parked out of the consolidated fund of India for use during contingency situations by the government, for which they do not require approval of the parliament at that point of time. Parliament may by law establish a contingency fund in the nature of an imprest. Imprest is, you spend the money first, you come back to me later with the account of the money that you have spent, to be entitled the contingency fund of India, which into which shall be paid from time to time sums as may be determined by such law, and such fund shall be placed at the disposal of the president to enable advances to be made by him out of such fund for the purpose of meeting unforeseen expenditure pending authorization of such expenditure by parliament by the law under article 115 or 116. One more thing, it brings me to an important concept. Abhi meko dhyan aaya. I hope all of you know what is the concept of vote on account. Do you know the concept of vote on account? Vote on account pata hai? Okay. So please have a look at provisions of article 116, vote on account, and vote of credit. Do you understand what is the difference between vote on account and vote of credit? See, the parliament approval is required for spending of any money by the government. Any money from consolidated fund. But there is a problem. What if the budget for 2026-2027 gets approved on 10th of April? What will the government do for 10 days? Government cannot spend money unless parliament has given approval. But budget is getting approved on 10th of April. Possible? What is the government going to do for 10 days? Just going to sit idle. The entire country will go into doomsday if the government was to be sitting idle in this country for 10 days. So then, what happens? Before the parliament goes into a recess, where the department related standing committees become active, and before the discussion on demand of grants takes place in the budget session, the parliament passes what is called as vote on account. They tell the government that we are giving you in principle approval for the budget. Go and spend money as per the budget provisions till the time we give final approval to the budget. So it is a pre-approval that is given by the parliament to the government so that they can go and make the necessary expenditure that is required till the time the budget is approved by the parliament. This is a stopgap arrangement that we have in our country, which is called as vote on account. Then what is vote of expenditure? So if you see vote on account, notwithstanding anything in the foregoing provisions of this chapter, the House of People shall have the power to make any grant in advance in respect of estimated expenditure for a part of any financial year, a grant in advance in respect of estimated expenditure, budget, for a part of any financial year pending the completion of procedure prescribed in Article 113, which is basically nothing but approval of the appropriation bill, etc. and all of that, for voting of such grant and the passing of such law in accordance with provisions of Article 114 in relation to that expenditure. But what is vote of credit? Let's say the government has put up some budget. During the year, India goes to war or some pandemic strikes and the government needs money for that expenditure. But the problem is government doesn't know how much money it will require. It's an exceptional situation and they cannot even tell how much money they require for that purpose. Pandemic आ गया है, vaccine develop करनी है. I don't know how much money will be required because I have not done this job before. So what will the government do? They will go to the parliament and they will say that this is a blank check. You please sign on this blank check and allow us to spend money for this exceptional purpose where we cannot even state how much money is required. When we spend, we will come back to you and you give us a final approval. हम आपसे लेंगे जब खर्च कर देंगे, receipt आपको देंगे आके. But अभी के लिए blank check दे दीजिए. What is the difference between this and exceptional grant? Exceptional grant is for exceptional purposes, for spending during the financial year, but I can at least tell how much money I need. I can tell how much money I need. In vote of credit, I don't even know how much money I need. So see the difference. So again, I'm reading 116 clause 1 subclause B. Notwithstanding anything in the foregoing provisions of the chapter, House of People shall have. Again, please notice, House of People has the power. राज्य सभा क्या करेगा इसमें? House of People shall have the powers to make a grant for meeting an unexpected demand upon the resources of India when on the account of the magnitude or the indefinite character of the service the demand cannot be stated with details ordinarily given in an annual financial statement. Because the magnitude and the character of the expenditure is such that I cannot state it on paper. I am asking you for a blank check. But then see, exceptional grant क्या है? 116 clause 1 subclause C. To make an exceptional grant which forms no part of the current service of any financial year. Again, there are basically different type of grants made by Parliament during financial year. Okay. One is exceptional grant, which is there is some situation that has arisen for which I need money from you, which is not mentioned anywhere in the budget. I will ask for what is called as exceptional grant. Then there are two others: additional grant, and then there is something called as excess grant. One example that I always give in my class, those of you who have attended my class, is that you go for, you take your friends to a birthday party, to a restaurant, and there you had asked your parents for, let's say, some X amount of money, or you didn't ask your parents for money, you said that 10 friends have to be taken out. You go there, your parents, your father has given you 500 rupees to take your 10 friends to a restaurant for eating food. Now you can guess how much food you will be able to eat in 500 rupees. Your father is reminiscing his days कि 500 रुपए में तो हम पूरे गांव का खाना खिला देते थे, तो 10 लोग को क्यों नहीं खिला सकता ये? सो यू विल गो टू द रेस्टोरेंट, राइट, एंड यू find there that the money that has been given to you is not enough for meeting the purpose for which it was given for. You had asked money for food, but there is not enough money that you have for meeting that particular purpose. You will ask for what is called as additional grant. So if you read, if you come to this article 115, supplementary, additional और excess grant, तीन होते हैं, चार होते हैं in fact, है ना? Supplementary grant as well. We'll start from this. Supplementary grant से start करते हैं पहले. Supplementary grant. The President shall, if the amount authorized by any law made in accordance with the provisions of Article 114 to be expended for a particular service for the current financial year is found to be insufficient for the purpose of that year, or when a need has arisen during the current financial year for supplementary expenditure upon, additional को भूल जाइए, supplementary expenditure upon some new service not contemplated in the annual financial statement for that year, then you require what is called a supplementary grant. So you went to the restaurant, you had taken your friends for food there, you realize that 500 rupees is not enough, you will go back to your parents and you will ask, please give me additional grants or supplementary grants to fulfill the purpose under that service which I had already asked the money for. So the service was food. Now you are asking some supplementary grant to aid what is the deficit that you have, because you know that this money will not be enough for meeting the purpose. Additional grant is for a service associated with an existing service. You went to the restaurant, you had taken your friends for food there. This was the existing service in the budget. You realize that 500 rupees is not enough for food. You ask more money for food, supplementary grant. But your friends also want to drink there, right? So drink doesn't mean what you think, okay? Drink can be other drinks also. So when you go there, your friends want to drink also. Drinking is a service that is associated with an existing service which is food. So you will ask for additional grant. Third is excess grant. I was given 500 rupees, I did not check the menu. I ended up spending 5,000 rupees. So I have already spent in excess of what was allocated to me. So in that case, I will ask for what is called as excess grant, which is mentioned, if any money has been spent on service during a financial year in excess of amount granted for that service and for that year. 116 clause 1 subclause B. Sorry, 115, not 6. 115 subclause 1, clause 1 subclause B. Excess grant. Additional grant, supplementary grant, understood? Associated with the existing service, additional grant. For the existing service, supplementary grant. Already spent in excess, excess grant. Exceptional is that you've now reached the restaurant, some of your other friends also come there. This is something that you had not contemplated at all. Your relatives come there and they say that you give us the treat as well at the restaurant. This is something which you had not anticipated. This is something that has come up now during the current financial year. But you know what is the amount of money that will be spent. Exceptional grant, exceptional purpose. Vote of credit will be when you cannot even state how much money will be required for this purpose. So you ask for a blank check. You had anticipated to go to a normal restaurant, your friends took you to a 5-star restaurant, 5-star hotel. Now the problem is that you don't even know how much money will be required. So you tell your parents that please send property papers. This is what is called as vote of credit, blank check. ठीक है? Understood? Anyway, so ये हो गया जो भी है grants वाला thing also which we have done. One other important concept that you need to know is related to the passing of the budget. Okay, so passing of the budget से related जो है उसमें the concept to remember here is that what is the process? Annual financial statement is tabled by the finance minister who causes that annual financial statement to be tabled in front of the parliament, the president of India. The cause is the prime minister. UPSC कहती है साहब prime minister of India is the one who is the cause of laying down the annual financial statement in front of the parliament. Absolutely wrong. I don't know why they said that. So see, Article 112 clause 1. The president shall in respect of every financial year cause to be laid before, he's the cause. On behalf of president, the finance minister will go and lay down the annual financial statement. Because president is the head of the executive. He's the one in whose name all the actions of the union government are being taken. The president shall in respect of every financial year cause. He's the cause. He's the one who's triggering this action. To be laid before both the houses of the parliament a statement of the estimated receipts and the expenditure of government of India for that year, in this part referred to as annual financial statement. So what is annual financial statement? It is nothing but estimates of receipts and expenditure of the government for that particular financial year. You should also know that annual financial statement includes the revised estimates of the ongoing financial year in which the budget is presented. So 2026 के budget में revised estimates of 25-26 थे, actual estimates of 24-25 budget थे, and it has the estimates of 26-27. Three things are there. Another important thing to keep in mind, in the expenditure, it is important for you to tell what will be capital expenditure and what will be revenue expenditure. This is a constitutional requirement. So you can see that the I'm reading clause 2 of 112. The estimates of expenditure embodied in the annual financial statement shall show separately the sums required to meet the expenditure described by this constitution as expenditure charged upon CFI, and the sums required to meet other expenditure proposed to be made from the CFI, and shall distinguish the expenditure on revenue account from other expenditure. These are constitutional requirements. So when you show the annual financial statement, there has to be specific categorization: capital expenditure, revenue expenditure, and also charge expenditure, non-charge expenditure. What all expenditure is charge expenditure? For that you have to read provisions under Article 112 clause 3. Please read them later. पढ़ लीजिएगा. This can also be a question in prelims. Which of the following expenditure are a charge expenditure under the Constitution of India? एक ये question हो सकता है. Which of the following is a charge expenditure? वो एक अलग हो सकता है. Because see, you must understand one thing. Some expenditure may not be explicitly mentioned in the constitution as a charge expenditure, but parliament can make a law and can declare an expenditure to be charge expenditure. We discussed about that in the morning today, right? Parliament can make a law and can declare an expenditure to be a charge expenditure, right? So that is not directly under the constitution, but that is derived from the constitution. So that can also be a possible way in which UPSC may try to confuse you in the exam. So please do read Article 112 clause 3. Anyway, annual financial statement tabled in the parliament tabled in Lok Sabha by the finance minister. Finance minister gives a speech. After that, the same annual financial statement along with other documents is tabled in Rajya Sabha as well. Finance minister may give a speech, may not give a speech, doesn't matter. Post that, for 2-3 days, there is a discussion that happens in the parliament. Whatever will the duration of the discussion, that the Parliamentary Affairs Committee, etc. will decide. So, the discussion will take place in both the houses of the parliament separately on the provisions of the budget. Very generic discussion, very broad, superficial discussion will take place. After that, parliament goes into a recess. And during this period, department-related standing committees of the parliament become active and they scrutinize the demand of grants that have been made by different departments of the government of India. They come out with their reports on what expenditure is warranted, what is not warranted, what is required, what should be removed, what should be cut down, etc. and all of that. Parliament reassembles. Then parliament discusses demand of grants in each of the houses separately. But the motions for cutting down the demand of grants can be introduced only in Lok Sabha. Once those cut motions etc. are introduced, after that the demand of grants are voted, either guillotined or voted upon separately, and then after that the next is appropriation bill, which is to withdraw money, but you also need to put money. So where will that come from? Taxes in form of finance bill, which is more or less, as I said earlier as well, nothing but money bill. And once that is passed by the parliament, approval given by president, budget stands passed, and that's the end of the entire budget cycle in the country. Right? This is the process that is supposed to be followed. Again, see, I mean, I can't go into details. Now, some of you, if you think कि सर ये तो बहुत fast पढ़ा रहे हो, मैं पढ़ा नहीं रहा हूँ यहाँ पे. We are just doing a revision of the concepts that we already know. Okay. Anyway, so all of this we have discussed, parliamentary grants, etc., and all of that. Now, this is again something on which a lot of times students get confused. This is very simple, but I don't know why people get unnecessarily worried and they complicate the concept here. We all know that if Lok Sabha dissolves, it can have effect on pending bills. It can have some kind of effect on pending bills in the parliament or bills that have not become law. What is the effect? Let's understand very quickly. एक बहुत simple सा rule है, वो समझ लेंगे तो सब समझ में आ जाएगा. See, if a bill, the thumb rule is this, okay? If a bill, and this was a thumb rule that was once told to me by a former Secretary General of Lok Sabha, Dr. V.K. Agnihotri. And if you just remember this rule, you will never go wrong with this concept, which is if a bill that is not passed by both the houses yet is touched by House of People, then upon its dissolution, such a bill lapses. Now pay attention to what I have written here. If a bill that is not passed by both the houses of the parliament yet is touched by House of People, then upon its dissolution such a bill lapses. Now understand. First scenario, bill introduced in Lok Sabha, pending in Lok Sabha, and then what happens? Lok Sabha is dissolved. What will happen? Bill will lapse. Second, bill introduced in Lok Sabha, passed by Lok Sabha, sent to Rajya Sabha, pending in Rajya Sabha, upon dissolution of Lok Sabha, this will lapse. Bill introduced in Rajya Sabha, passed in Rajya Sabha, sent to Lok Sabha. This is where maximum students make mistake. Sent to Lok Sabha means it has already been taken into consideration in Lok Sabha, first reading has happened. Upon the dissolution of Lok Sabha, bill will lapse. Fourth, bill introduced in Rajya Sabha, pending in Rajya Sabha. Lok Sabha dissolves. What will happen? Not lapse. Right? Not lapse. This is simple. The last one is bill introduced in Lok Sabha or Rajya Sabha, doesn't matter, passed by both houses. Pending in front of president. Will it lapse? No. Not lapse. ठीक है, बस यही है, इतना है, और कुछ नहीं है. Thumb rule, as I said, if the bill that has not been passed by both the houses of the parliament is even touched by the Lok Sabha once, that bill upon the dissolution of the Lok Sabha shall lapse. Is that clear to everyone? ओके, सो बस इतना ही कहानी है और कुछ नहीं है इसके अंदर. एनीवे, ये एडजर्नमेंट और ये सब चीजें हमने डिस्कस कर ली हैं. वी डोंट नीड टू डिस्कस दिस अगेन. व्हेन इज अ जॉइंट सिटिंग कॉल्ड? इज इट मैंडेटरी टू कॉल अ जॉइंट सिटिंग इज माय क्वेश्चन फर्स्ट. सी, पहली बात तो जॉइंट सिटिंग इज कॉल्ड व्हेन बोथ द हाउसेस ऑफ द पार्लियामेंट disagree on passing a bill in a common form, or if there is a certain amount of time that has lapsed when bill was sent from one house to the other and the other houses failed to act. In that case, the president may call for a joint sitting. So let's read the provision exactly. This has been mentioned in Article 108. If after a bill has been passed by one house and transmitted to the other house, the bill is rejected by the other house, both are not agreeing on the bill, or the houses have finally disagreed as to the amendments to be made to the bill. One house passed the bill, sent it to the other one made some amendment, sent it to the other one said no, they passed the bill in another form again. So at some point of time you will say that they have disagreed on the common version of the bill, or more than 6 months elapsed from the date of the reception of the bill by the other house without the bill being passed by it, the president may, please notice may here, unless the bill has elapsed by reason of dissolution of House of People, notify to the houses by the message, if they are sitting, or by public notification, if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting on the bill. Is that clear? Only 3 joint sittings of the Parliament of India have been organized till now, is what you need to know. One was on the Dowry Prohibition Act, the another one was on the Banking Service Commission Repeal Act, and the third one was on the Prevention of Terrorism Act. बस इसके अलावा किसी भी और बिल के ऊपर जॉइंट सेटिंग नहीं हुई है. तो इसी से ही पता चल जाता है एक चीज, दैट जॉइंट सेटिंग इज नॉट मैंडेटरी. होता तो आपको नहीं लगता कि कितने बिल्स के ऊपर डिसएग्रीमेंट हुआ होगा लोकसभा और राज्यसभा के अंदर? तो फिर तो कितनी बार जॉइंट सेटिंग हुई होती. So there are only 3 times when this has happened, and it is not mandatory. It is a decision that is supposed to be taken by whom? Council of Ministers, Government of India. Again, President अपने से नहीं करेगा ये सब, on Council of Ministers advice, right? So this is another point that we need to keep in mind. Now, अच्छा, एक और चीज, constitutional amendment bill, can there be a joint sitting? No. Why not? Why can there not be a constitutional amendment bills joint sitting? What? Prior permission of president? Break the federal structure? Arey, forget about this yaar. Article 368 simply says that any amendment to the constitution has to be made only and only according to provisions of Article 368. Does Article 368 mention about joint sitting? No. Article 368 is very clear. Both the houses of the parliament have to separately pass the bill by a special majority of each of the houses of the parliament, presented to the president, who shall assent to the constitutional amendment bill. Is that clear? That is the reason. See, all of that logical answer ki it will affect the federal structure, this, that, वो सब एक अलग बात है. Fact is that constitution, if it has to be changed, it should be changed by agreement of both the houses of the parliament, not by just one house. If you give constitutional amendment bill also a joint sitting, Lok Sabha will do whatever it wants to, and Lok Sabha is driven by populist considerations. तो ऐसे लॉजिक तो मैं बहुत सारे दे सकता हूं, but constitutional logic is Article 368 is the only provision that relates to amendment of the constitution, and that does not talk about the provision for a joint sitting. Is that clear to everyone? Now, another thing, राज्यसभा पे आ जाते हैं. So we have reached only T7. Wow, we thought 50, but we'll see. Anyway, so composition. All of this is known to us. I don't need to discuss कि कैसे राज्यसभा composition होता है and all of those kind of things. Rajya Sabha cannot be dissolved. 1/3 of the members retire every second year. And what is to be remembered is that what are some of the exceptional or exclusive powers of Rajya Sabha. वो एक चीज डिस्कस कर लेते हैं, which is if Rajya Sabha passes a resolution by a majority of not less than 2/3 of members present and voting, please remember this, it is not special majority. If Rajya Sabha, that is Council of States, passes a resolution that is approved by 2/3 of members present and voting, that it is important in national interest for Parliament to pass a law on a subject mentioned in which list? Yes, mentioned in list 2, state list. Then Parliament becomes competent to pass a law on that subject which is mentioned in that resolution. उस resolution में उस subject का mention होना चाहिए कि हम Parliament को empower कर रहे हैं. We are empowering the Parliament to make a law on this particular subject that is mentioned in this resolution. But here is the thing. This resolution has a validity of only 1 year, which means that Parliament can pass a law on this subject within that time frame of 1 year alone. Rajya Sabha can extend the validity of this resolution by passing the resolution again. But at one time, you have only 1 year to make the law. One is that. And you can make law only on that subject which is mentioned in the resolution. Third thing. Let's say Parliament goes ahead and makes a law on a subject which is mentioned in the state list. As per Article 249, under national interest. The point to keep in mind is that this law also has a certain validity. This law can remain in effect only up to 6 months after resolution ceases to have effect. Matlab, let's say if Rajya Sabha passes the resolution on 6th of March 2026, and let us say Parliament makes the law on that subject on the same date, this law max can continue up till kitna ho gaya? 6th of September 2027, 1.5 years. Do you understand what I'm trying to say? Again, see, UPSC is not going to give you calculations, but you need to remember the concept that this law can remain valid only for up to 6 months after the resolution ceases to have effect. Okay? And resolution's validity itself is for 1 year. Is this clear to everyone? Then, another special power of Rajya Sabha is Article 312. Please read Article 312 quickly. This is the last topic. We'll stop it here. We'll see what we can cover tomorrow. देखते हैं क्या हो सकता है. Notwithstanding anything in chapter 6 of part 6 or part 11, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting, again same, that it is necessary or expedient in national interest so to do, Parliament may by law provide for creation of one or more all India services common to the Union and the states and subject to other provisions of this chapter. See, all India services have an impact on federal functioning, because these officers will be chosen by the government of India, but they will be working with the states or working in the states. So you need some kind of approval from the states. And who gives approvals on behalf of the state? Rajya Sabha. So again, Rajya Sabha has to pass a resolution by 2/3 majority present and voting. जब वो अप्रूवल देंगे उसके बाद पार्लियामेंट को लॉ से ऑल इंडिया सर्विस क्रिएट करनी होगी, अपने आप से ऑल इंडिया सर्विस क्रिएट नहीं होगी. यही वही वाली बात है. 249 में भी राज्यसभा खुद से लॉ नहीं बना देगी. राज्यसभा केवल पहले अप्रूवल दे रही है. देन पार्लियामेंट हैज टू गो अहेड एंड मेक द लॉ. Similarly in 312 as well, Rajya Sabha will only give approval on behalf first, approval comes, and then the parliament can make a law to create some kind of an all India service in the country, including AIJS. Including AIJS. AIJS was included there by the 42nd Constitutional Amendment Act. So the ground is actually cleared. अगर AIJS बनाना होगा तो प्रोसेस क्या है? सीधा पार्लियामेंट लॉ पास करके AIJS बना सकती है क्या इंडिया में? नहीं. First, राज्यसभा has to pass a resolution. Then the parliament has to subsequently make a law and AIJS will be created in the country. That is the process that is supposed to be followed here. And then you have the All India Judicial Service referred to in clause 1 shall not include any post inferior to that of a district judge and so on and so forth. So this is also an important point. AIJS has been in news. So AIJS, they may ask a question. Can, let's say, the post of additional magistrate be recruited by AIJS? The answer is no. Can you recruit someone inferior to a district judge? The answer is no. Only persons of the level of district judge can be recruited via AIJS. This is to bring in some kind of symmetry, some kind of uniformity in the standards with respect to the lower judiciary or the district judiciary in India. Okay. Okay, so we stop the session here. We will continue with it tomorrow. There is this, I'll just show it to you quickly. This is the sort of